May I please your lordship, my lord, I beg to mention item 40 of today's supply order, my lord. My lord, this is a IF criminal, my lord, for parole, my lord. The mother of the
14,
48, my lord.
48.
48. My lord, it is paid for filed for parole, my lord. Mother of the appellant, my lord, expired. So, my lord, the days are not, list is very long. May it be taken at 2, my lord. Today the list is very long, may not reach, my lord, very urgent otherwise, my lord.
Why are you saying? I cannot.
My lord, I filed the IA criminal, my lord, for granting parole, my lord, as his mother of the appellant in jail has expired, my lord. So to allow him to appear in the last rites, my lord, I have filed this one, my lord. So the vacation is near, my lord. So, my lord, may it be taken at 2 p.m. Obliged. My lord, one more prayer, my lord, a bail application filed, my lord, only for CD calling, my lord, on Friday, my lord. Or,
Which one?
my lord, another bail application I have filed, my lord. My lord, new bail application.
BA.
BA, my
No.
My lord, in custody, my lord. And only for CD calling, no, I will not insist for, my lord, interim, my lord. Day after, tomorrow or day after, my lord.
Tomorrow we have already fixed 15 or 16 matters, mentioned
It
matters.
is
We
take
cannot
only
fix.
day after, my lord. Then.
Day after also there is maximum.
Lordships, maybe also with the consider the other side, I recommend item number 12 and 13 of today's lordship. Kindly, matter taken on 8th of January, lordships. Today is having some personal difficulty. 12 and 13, your lordship.
7, 8, 6, 7, 8. We have fixed lots of matters on 6, 7, 8. Most probably it
If
may not be possible. Let it be after Bihu only.
after view done on 19, your lordship, 19 or 20.
19 is the open day.
Yes, open day.
12 and 13 you are saying?
12 and 13 also.
You are for the petitioner?
Yeah, I'm for the petitioner in 12 and 13 is a respondent. I have considered all the parties, your lordship.
Consent of the petitioner in criminal petition number 1 of 179 of 2025 and respondent in criminal petition number 72 of 2025. Wait for an prayer out. Please my prayer only 20 you say 20 20
Lordship.
May I please, your lordship? I pray for listing of a new anticipated bill episode on Friday, my lord.
Approach the registry.
But without mention.
We are not listing any AB. We are not considering the mentioning of any AB. Pray before, made a mention before this registry, they may accommodate in any other court because I have already fixed many matters.
Yes, ma'am.
So it's not possible.
If registry will not allow me, then I will approach, my lord.
No, you can approach the registry before AB.
My lord, this is a bail application, my lord. Day after tomorrow.
Day after tomorrow is already.
My lord, this I have filed it on 5.
Maybe on 7th.
On 5/12 I have filed it, but still not listed. So my lord, because already 10 days have been enough for filing. Kindly, my lord, day after tomorrow. Bail application have been jailed, my lord. Brother AB, my lord, I am not mentioning this. Still not mentioned, only this one.
Make a mention before registry. Approach the registry first.
My humble
They may
submission,
accommodate it.
my humble submission, both two other AB, that I am not mentioning. Only this one because I have filed it on 5/12. So this is at least my deserved, not recently filed,
How you
but not listed. Only this one, my lord.
reservation? I have rejected one prayer of someone now.
This is a bail application, my lord.
No, bail.
Day after tomorrow, my lord. Not tomorrow, my lord.
Because I have you know, you know. I hear the food come up extra. One now below opinion. What do you have?
My lord, I'd like to mention this item for withdrawal, my lord, for tomorrow.
I am praying for listing a bail application, my lord, on Friday, my lord. Pending matter, my lord. Last-
Approach registry.
Last, my lord,
We are not
7 months in jail, my lord.
approach registry.
Lordship, we
They may accommodate in any other.
Lordship, we deconcept of the other side. I'd like to mention item number 34, my lord.
All the petitioner.
Petition, no?
27.
You are for the,
27.
I'm for the petition.
you are for the response?
I am for the petitioner in the main criminal petition, and we are the opposite party in the IA. They are the respondents in the main criminal petition.
Whatever, you are the petitioner.
I am the petitioner.
I is for what?
I is for vacating of the interim order, my lord, and lordship on 15/9/25, there is an order, lordship, I am placing it, that this matter, the main criminal petition may be heard for disposal instead of hearing the IA, lordship. So it may be listed on the admission column on 22nd, lordship. 27th of January, lordship.
22?
Interim order may be
Consent of the other
continued.
side.
Interim order is there.
The consent of the other side, and the council for the petition. Wait for an adjournment. There are pasting at 27/1/26. Interim be continued. in the first. But you are taking advantage of interim and you are listing it case. And the other side is, that's why they are appearing before this court for vacating the interim order. Because you are
Lordship, there is
enjoying
an
the
order that the main
enjoying
criminal
the
petition may be
interim
heard for
order, na?
disposal.
stay order, that's what. Okay, we're listing it on 27, try to
Okay.
go for the hearing on 27/1.
Interim order is there.
Yes, I will continue. Interim order will continue.
May I
Yeah,
please, your lordship?
My lord, I filed a bail application, my lord.
Approach the registry, they may accommodate in any other court. We are not in a position to list. That's,
If it is,
Okay.
they have got tomorrow.
no way. Approach the registry, they may.
May I please, your lordship? Your lordship, I beg to mention item number 38, your lordship. In this matter, your lordship, TCR was called for, but that is not received, your lordship. So a reminder may be issued, your lordship, and a date may be fixed after vacation, your lordship.
So you have,
It-
let the matter be reached, eh? Let matter be reached.
So I to mention item number 18.
Hmm.
I put the respondent number 2. I have taken the consent from the other side.
Lordship, I appear for the petitioner in this case, Lordship. Herein, Lordship, it was heard earlier. So I paid,
Heard by which court?
your Lordship also heard it, Lordship,
Oh.
and it was ready to be disposed of. So I pray that it may be fixed on 19 or 20, Lord. No idea.
Hard week of January, any date.
Third week of January will be 1920.
Lordship.
Lordship.
Yes, Lord.
19th or 20, any date.
Here,
Oh,
It may not be returned back, Lord.
it has to be.
It was
Has
to
to
be
be
returned.
returned.
As per the last order, Lordship, it was to be retained, Lordship.
Detained till the date today. Now you are seeking adjournment, it will be fixed after 1 month, more or less after 1 month. So CD has to be returned, otherwise there will be hamper in the investigation. We are calling for the up-to-date one. So you are for the whom?
I am for the respondent number 2.
Respond number 2. So you are representing the petitioner
Yes, Lord.
with the consent of the other side and counsel for the respond with point adjournment. In that context, Mr. Sharma, till an additional PP submitted that received the CD. They have already received the CD. In view of this, let the CD be returned following updated case diary. And both the parties are hereby asked to proceed with the hearing to the next stage without further adjournment. This is the matter accordingly on 19, you are saying?
Yes, Lord.
20, 20 or 19? 20.
Lordship. Like,
Much.
May I present, lordship? Lordship, I beg to mention item number 11, lordship. Lordship, I do withdraw, lordship.
You want to withdraw this one?
Lordship,
You are for the petitioner.
lordship,
Your good name?
S. Pradhani.
S. Pradhani.
Lordship.
Heard Mr. S. Pradhani. The learned counsel for the petition. It is submitted that as per the instructions of this client, he wants to withdraw the CD. So, where and accordingly disposed. Okay, it is disposed of on withdrawal.
Lordship,
It will be disposed of on withdrawal.
Pavlas, lordship.
I'm praying for listing and bail application for withdrawal, lordship, may taken on tomorrow.
Yeah, please, your lordship, I'm praying for listing on bail application, your lordship.
make a mention before registry, approach registry, it may be accommodated within 5 days.
May it please your lordship, lordship, I'm praying for listing of a BA for withdrawal, lordship.
Hmm?
For withdrawal,
Day after tomorrow.
highly obliged.
Let please your lordship. Lordship, item number 50 of supply list, lordship.
50.
50, lordship. Criminal petition, lordship. And the informant and the accused petitioner, lordship, and they have filed joint petition, lordship, for quashing of FIR, lordship. And for the petitioner number 2, and they filed the Ukalatnama yesterday, lordship, his name is not appearing in the position. Lordship, after vacation, lordship, can it be 6 and 7 of January, lordship? 6 or 7.
So as per you, for the respondent number 2, someone had appeared,
Lordship,
filed wakalat.
file Ukalatnama. Lordship, the informant and the petitioner, both they are jointly filed this petition, lordship.
So who is for the respondent number 2 now?
Respondent to state, lordship.
State is to there.
But the petitioner number 2, lordship, and the informant is petitioner number 2, and the accused is the petitioner number 1. Jointly, they have filed this for quashing,
Joint petition.
lordship.
So the question of appearing for the respondent is
Lordship,
Just
and
not
the
there.
petition number 2, lordship, and another advocate is filed Ukalatnama, lordship, yesterday.
I'm not just following.
But
you.
earlier
You are
instruction
saying
by
it
the
is a joint petition.
lordship,
isn't it?
joint petition. But yet the honorable
So
court directed
who appeared now? Who appeared now?
A.S. Sharma, lordship, Akim Sharma.
My lord,
He is
my
supposed to
understanding is that, my lord, although they have filed a joint petition, my lord, perhaps for a respondent number 2, another advocate will appear.
lordship.
They have filed Ukalatnama.
No, but he is saying there is no respondent number 2.
Not, my lord, but here both
Is it
petitioner and
petition number-
respondent, both joint petition.
Joint
There is joint
Petitioner and
petition.
respondent both have filed a present petition.
But
Joint
even earlier,
I'm saying
lordship,
both the petitioner and the respondent they
And
have
the-
jointly filed the petition
Hmm.
for quashing and all. Now he is saying someone is appearing for the respondent. Respondent is
lordship,
the state.
not respond. Lordship, and earlier occasion, lordship, the honorable court directed to file another Ukalatnama for petition number 2.
Petitioner number.
That is why
Petitioner-
Petitioner number 2.
petitioner number.
can be 6 or 7.
Mr. F. Hawk, the learned conflict petition. Also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Hawk that the present criminal petition for quashing is filed jointly. However, as per direction of this court, one counsel has already filed as Wakaratnama to represent the petitioner number 2.
Lordship.
However, his name has not been reflected in the cause list. In view of this, the registry is hereby directed to reflect the name of the counsel who is representing petitioner number 2 on the next date of court. Registry matter according you want some 6,
6.
7,
6. Obliged, lordship. Deeply obliged.
6, 1.
6.
Right, please, Your Lordship. I beg to mention item number 21, my lord. And this matter will be taken after vacation, my lord.
21, what you're saying? After vacation, you
My
have-
lord,
this is filed by the state
my lord, state, my
for
lord,
cancellation.
my lord, my lord, it was filed when one report was called for, my lord, in the earlier occasion, my lord.
Hmm.
That report also not received, my
The report is to come from
Reg-
IO.
lord. My lord, from the IO, my lord, IO.
Heard Mr. B. Sharma, the learned constitution, state. And also heard Mr. D. Boda, representing the respondent. It is submitted by Mr. Sharma. The report was called for from the investigating officer, but it's not been received yet. Issue reminder, call for the report. Please the matter accordingly. After
After you,
1920.
after Bihu?
Obviously.
When?
No, I have approached the registry, my lord.
Approach the registry.
No, I have approached the registry, my registry says they will not accept my application, my lord.
Okay, then it will be listed on 6th of January.
But day after tomorrow, my lord.
6th of January now.
He say
That's
Abbey, my lord,
very
his liberty is in stake, my lord. He say Abbey, my lord. Anticipated bail-
AB.
Yes, my
Oh,
lord.
AB though we are not going to list. AB
But
is
I have approached the registry also, my lord.
approach.
Look, I have
we are not
approached
going
my-
to list.
But I have approached, my lord. They say, well, we will not accept this, my lord, petition, my lord. This is a
We are
problem.
not listing AB because it cannot be considered as so urgent. That's why it will may be listed on 6th of January and in that case. It is the AB after all, isn't
Yes,
it?
ma'am. Well,
No,
obviously, ma'am.
no person is in detention. So It can be listed on
But his
6th of
personal
January at best.
liberties in stake, anytime he may be
6th
asked.
of January in best. 6th of January. One is educated delay. Every two is not educated. I think we do.
May I please, Your Lordship? Your Lordship, as per the instruction of the petitioner, Your Lordship, I may be allowed to withdraw this petition.
Want to withdraw this one?
Yes, sir.
As per the instruction. The and also. Then, Mr. You are Mr.
IH Lasko.
I.H. Tilani deputy submitted it as per instructions. And he wants to withdraw. It will be disposed of on bid.
I love it.
Okay. Forty? 45.
Withdraw.
Withdraw?
Yes.
Your good name?
N.A. Begum.
NAP. Same order. Huh? We are disposing it on withdrawal.
God bless.
May I please? In this case, what happened, the charge sheet has been submitted. So Lordship may allow to withdraw approach to the trial.
So you do have your charge sheet number, CS number.
No, it is
You got
informed by us, they have been, yes.
your good name?
A. Chetty Lordship on behalf of Mr. P.D. Nair.
A. Chetri,
Yes, Lordship.
appearing on behalf of Mr. P.D. Nayak, submitted that as per the instructions of his client, he wants to withdraw the same as case has already been charged. In view of this, case is accordingly disposed of.
Right, oblige this.
My lord, LCR.
TCR, sorry.
Now it is TCR.
TCR.
Part Mr. N. Vijay and part Mr. P. Sharma, Ilana Television TV.
কি করি না?
TCR for reasonable including input. Immediately, you want immediately after vacation? Mr.
My lord, let it be on 22nd of January, my lord. And my lord, if they want to file any objection, they may file within that period. Otherwise,
Further,
file করে দিন। এটা কি?
it being public
Oh, bail.
secretary that we were to file their written objection. If I, okay, if they may file.
I'm sorry, Prabhu.
Wait, please, Your Lordship. 483 bail application. My lord, the FIR is at page 14. Some Facebook post was, my lord, given by the petitioner, my lord, at page 14, my lord. May I read, my lord?
Yes.
I am writing to formally report that on 11/11/2025 at about 10:15 a.m. an information was received through the cyber cell Bongaigaon, stating one person, namely Riazul Ali of Bongaigaon, has posted an objectionable comment on a Facebook post through his personal account Rafizul Ali. After receiving the information, the aforesaid person was brought to North Bongaigaon PP for examination and inquiry into the matter by such and such. During examination, it was revealed that on the evening on 10/11/2025, the said person has made objectionable comment on Facebook post regarding the recent blast in Red Fort in Delhi through his Facebook account having the following number. My lord, what is the content? Nothing has been, my lord, revealed. And my lord, the in forwarding report at page 16, my lord. Page 16, para 3, my lord. In course of investigation, the mobile phone along with the SIM card has been recovered and seized from the possession of the accused person, my lord. Already everything has been, my lord, seized. And my lord, in similar, my lord, situated person, our High Court has, my lord, already released on bail on 11 day, my lord. He is behind the bar for 35 days, my lord.
Out of same FIR? No.
My lord,
Out of same FIR? Out of same FIR.
No, my lord, that is
Different.
Borpeta PS, my lord. He was arrested on 13/11/2025.
No, see, I don't know, they may be considered. But there the comment was that the election or time out able hoi thake. But here it is a blast.
My lord,
and
red
black
fort,
hole.
my lord. When
So see the difference.
my lord.
They may make some comment in the proposed book, so that may be election or during election.
It is different.
Election time, these kind of things are. But your case is your petitioner is. I don't know what was the objection, post or what, but it is not here.
On reopening, my lord, on 3rd May.
On? Third?
Third
Third is our holiday.
Third holiday.
Third is our holiday.
of my lord, 5th, on 5th. my lord.
Fifth is our holiday.
5th of May.
No, fifth
We may
opening,
fix-
reopening.
and based on reopening, if you want, then on 7th maybe, because CD has to receive
My
it
lord.
otherwise. So we are fixing it on 7th.
My-
CDP call for fix. Yes, 3 is also your
Yes,
petition.
my lord, that is
My
the
lord, here-
Manipur PS, my lord, and there has, my lord, one typographical mistake. Meanwhile, I will file one IA, my lord.
Typographical
Yes, my
mistake.
lord, one.
First page, my lord. First item. First page, my lord. First item.
Hard Mr. answered learned counsel for the petition and it is submitted that while filing the bail application, there is some typographical error. And accordingly, he submitted that one. You are going to file the amended cost item.
Yes.
File the amended cost item. Prayer allowed, list accordingly after filing of the amendment. You file the amended cost, it will be listed for.
My lord, fix it on.
No, list accordingly only.
My
After filing of his amended cost item, it
Amendment
will be
of
listed.
Then, my lord, fix it on, my lord, Friday. I will file by today.
No,
Today's
we are listing it accordingly. If you file, it can be listed.
problem.
My lord,
Yes.
he is allegedly a member of the Bir Laksi Thana. My lord, page 23, he has been shown arrested. Not even 1 hour police remand is sought for. 41 days he is languishing in jail. Page 23, my lord, may kindly see.
Page 23 is an order.
Order, shown arrest, not 1 day, 1 hour remand. Because your lordship is aware, my lord, when the government came down on this organization, my lord, they were shown arrested in some FIRs, my lord, but he is not even an FIR name accused. His name even does not figure out. A 20-year-old boy, my lord, a national level Taekwondo player, my lord. I have annexed the certificates as well. My respectful submission, my lord, probably further custodial detention for the purpose of investigation is perhaps not required. Because page 23, if your lordship peruse, even the police have not paid for any remand as such.
My lord, here Lordship may call for CD, my lord. Here several allegations are there against him, my lord, including the extortion, my lord, demand of money.
My lord,
There
those are English language, my lord,
My
they are
lord.
writing, my lord, because your lordship will see. And moreover, my lord, I am yet to check the records, but I don't see that he was even communicated the grounds of arrest because there is no reflection in the order dated 7/11/2025. Because in shown arrested cases, the police somehow have this impression that perhaps they are not required to furnish grounds of arrest, which this court have time and again laid down that notwithstanding the fact that he has been arrested in a subsequent case, ground of arrest is compulsory. So there is no reflection of the same. Not even 1 day police remand. These are, my lord, sweeping sort of orders which are being passed for each and every accuses. There is no specific allegation, nothing.
Lordship may fix, my lord, short date, my lord. I will
Short
put
date,
the
his
case in.
mandatory period will be over by the reopening day. Please count it. In cases, my lord, which we also understand that diary is required, we don't make much submission in the motion stage. But certain cases, my lord, where prima facie detention is not required, 42 days. Count kore lo.
40 days. Then
Where it is? On his name is what? Some Ali, na?
Yes, yes, Rohan Ali,
Rohan Ali.
page 23, accused number 3. IO made a submission, magistrate allowed, only to that extent. No reason, nothing. This is
No,
the submission,
police
considering the
custody-
submission
police
made by.
custody was sought for, I think.
No, my lord, considering the submissions made by the IO and the material placed before me, the prayer of the IO for allowing him to be shown arrested, namely such and such, is allowed. He is in judicial custody. The wakalatnama also bears the signature of the jailer.
No, then subsequently seen the prayer of,
Subsequently, your lordship is reading which page, my lord?
no, in page 23 itself.
Yes, page 23, the prayer was made and the prayer is allowed. He is shown arrested and he is in custody in connection with this case also. Why his custody is required, whether grounds intimated, nothing.
My lord, page 23, my lord, last para, my lord.
Last
Last para, my lord.
Ah.
The IO has further submitted that from the statement of the witnesses and the investigation conducted so far, it is revealed that the FIR named accused person along with other associates have been doing illegal activity like extortion, criminal intimidation, criminal conspiracy, unlawful assembly, rioting, various organized crime, various
Half of the IPC is here.
in the state of Assam in the name of Pilasin, my lord. So-called, my lord,
This is a half of the.
socio-cultural organization.
That is what I am saying, my
The
lord.
allegation
Half
is
of the
from-
IPC is there. So, my lord, these
Allegation
are,
against him is from for a long time, my lord.
so not even no police remand, nothing sort, my lord.
No, police remand, that's what I was,
That-
the police remand for 8 days was there.
Fine.
Prayer.
My lord.
Prayer, but my lord, the
Prayer for
I
alleged
don't
police custody.
see any, my
For
lord.
a
in-
period of 8 days, my lord.
Seen the prayer of the IO for showing the above name arrested, showing them arrested with the instant case, along with the prayer for allowing police custody for the said accused in the instant case for a period of 8 days. But my lord, whether police, my lord will see page 24, the operative part, and even if I presume 8 days have expired long back, today is this 41 day. No,
No, you're saying repeatedly that no.
Yes, my lord,
custody-
police remand is
custody
not
was there
allowed.
For 8 days, but how many days
it is,
not there?
the order does not say even 1 day, my lord. This is the certified copy of the order, my lord.
So whether they were in custody or what?
My lord.
They were given police custody. It is not here, I think.
My lord.
Yes.
It's not reflected.
It is not reflected in the order.
That's why I'm saying for the CD, my lord. It will be revealed from CD, my lord.
My lord, I have,
Cases of 60 days offense.
yes,
Then 60 days will over.
41 days to hoye bole.
My lord, day after tomorrow, my lord, I will try.
You want to try it?
Fine.
List on the after CDB.
Oh, day after tomorrow to tomorrow na.
Interim 19.
My lord.
Okay, try it.
Fine.
Day after tomorrow before.
May appeal the officer. So this is second time admittedly, and this is test lordship scan copy of the trial court record may be called.
It's a charge sheeted case.
Charge sheet.
Scan copy of this we call for. Registry will be need list the matter when it can.
Ninth lordship.
No, first after vacation.
Ninth, yes, after vacation.
No,
Ninth,
my lord.
ninth of the
Several
month.
matters are, it will be harsh again, my lord, on 4, 5, 6, 7, 8, 9. Only 4, 5 days open.
19
Before 19, any case?
Vacation, new vacation.
No,
All
no,
right.
20.
20.
20.
Come on.
20.
May please, my lord. My lord, it is a case, my lord, the counter blast affair, my lord. The petitioner is a small, my lord, scale the business, my lord. It's a Galamal business, my lord. Galamal shop, my lord. Now, my lord, the page 13, my lord, this affair, my lord. May I read this affair, my lord? With due respect, I beg to inform you that the morning so-and-so, time at around so-and-so, my husband, Sri Oikmili, went out of the work in the vehicle bearing registration number so-and-so at the Panimiri Gaon, Tiniali. At the time of the two person, namely Rupnath Mili and Santosh Mili, my lord, the Santosh Mili is present petitioner, my lord, they stopped the vehicle, damaged it, and assaulted my husband with a dao, my lord. A bamboo stick and sword in an attempt to murder him, my lord. Kindly, my lord, to draw attention, my lord, next para, my lord. Then my husband managed to flee from the place of occurrence, my lord. That, my lord, this alleged victim
My lord, the many is the flee from the place of occurrence and took shelter is the brother, the Basant Millie house, my lord. And this affair, my lord, register under section, my lord, the 118 subsection 2 and 109, the grievous injury and attempt to murder. Now, my lord, I have lost an affair, my lord. 16/10/2025, the same PS, my lord, but my affair is entire affair ingredient in civil nature, so my case was not registered, my lord. And now, my lord, this present petitioner's fathers, I have annexed the interim bail, my lord. Page 25, my lord. This present petitioner's father granted, my lord, interim bail, my lord. So will appear, my lord. And before investigation officer, my lord, will cooperate in the investigation. Same both informant and, my lord, this victim, alleged victims, my lord, same blazer people, my lord.
The Yep. The notification again, there is anything else? Because as per the earlier notification,
My lord.
the case which has been disposed of by, suppose,
My
after
lord.
same FIR,
My lord.
it will go to that particular court.
That is there, my lord, but here it is perhaps interim order was granted.
Not final order, my lord, interim order.
It's not disposed of them.
Not
Yes,
disposed of.
not disposed.
6471.
It is pending. That's
Yes, my lord, pending, my lord.
that can be.
My
Yes.
My lord, here, Lordship may kindly page the FIR, my lord. From the FIR itself, reveals that, my lord, he is the offense in serious, my lord. Here it was initially he was admitted to my lord, PHC. Then thereafter it was referred to AMCH, my lord, for better medical treatment, my lord. Here Lordship may call for CD along with the medical report, my lord. After that, Lordship may consider their prayer, my lord. It is also not clear regarding their role, my lord.
At this stage, my lord, it will comes, my lord, the medical legal certificate, my lord, that the interim protection will be given, my lord.
B. Sharma is an application under section 7 submit to there was some authorization for which one cross case is also lost. One cross FIR was also lost by the petitioner side, but that was not registered as considering the same in civil in nature. Mr. Dr. further submitted upon the contents of the FIR itself, it is seen that husband of the informant they way try to able to rescue himself from the clutches of the used other the petitioner side post. No such incident had happened as allegedly FIR. However, petitioner is ready, willing to extend his cooperation, but in this case, if he is granted with privilege of arrest. Mr. Sharma, the learned petitioner, submitted in that from my FIR it is seen that the injury was serious in nature and for which the husband of the petitioner was husband of the informant was shifted to AMCH Dibrugarh for better. Accordingly, he insisted for case diet along with the injury. Next, taking the subject made by is to extend the privilege of interim petition to receive the is there to call for along with the media. He will be under interim protection, appear before the IO within 7 days and cooperate acting.
Deeply of respect.
My lord, the other case also fixed on 7/1/20.
7-1, yes, the other case maybe 7-1 fixed, my lord, but I am not available on that day, my lord. Only next, any date, my lord. After. 20, deeply of respect, my lord. May it please your worship. In an anticipatory bail application, the petitioner before your lordship, he runs a jewelry shop in Nagaon. Now, my lord will find the FIR at page 14. Yes, in Jorhat, a theft took place, my lord, and jewelry, including gold jewelry and diamond rings of the informant was stolen, my lord. Now, as far as the petitioner is concerned, my lord, the relevant document would be page 16, my lord. This part may I read, my lord? Page 16. First, my lord, brief of the case, my lord. On 19/11/2025 at 2:30 p.m., informant so-and-so lodged an azahar at so-and-so place under Jorhat PS to the effect that on 18/11/2025, accused unknown culprits had entered into the house of the complainant and has stolen away gold jewelry amounting to rupees 30 lakhs. They also disconnected the CCTV wire. During the course of investigation, sufficient evidence found against the below mentioned accused person to be involved in the case. The lordship will see the ground of arrest number 1. During investigation, it is found that accused Krishna Chaudhary, now in judicial custody, received the stolen gold ornaments from accused Soriful Islam, who dishonestly purchased the same from the prime accused persons of the case, namely Suman Sharma, alias Kosu, June Kolita, and Umakanto Naik, now in judicial custody. Later, accused Krishna Chaudhary illegally melted down the gold ornaments and sold it to the arrested accused Biswajit Saha, alias Tony, at his jewelry shop near the under the name Priya Jewelers, located at Nagaon. During investigation, melted gold of around 0.113 gram was recovered from the possession and jewelry shop of arrested accused Biswajit Saha, who in turn confessed his guilt of receiving the stolen property from accused Krishna Chaudhary. So Biswajit Saha is also a jeweler in Nagaon who had allegedly purchased some of the stolen gold medal from the prime accused. Now, this petitioner before your lordship, he runs a jewelry shop, and his jewelry shop is adjacent to the shop of this arrested accused person, Biswanath Saha, my lord. And now police is also searching for him, perhaps suspecting that since his shop is also located near the arrested accused person, Biswanath Saha's shop, so there might be some involvement in that case. Now, this petitioner, he has his own independent shop. He has absolutely no connection with Biswanath Saha's shop. Whether Biswanath Saha had purchased it legally or illegally from the arrested accused person, it's a different thing. But this person, the petitioner, Raju Das, not named in the FIR, no connection with this arrested accused person, but police from Jorhat are calling him. So that is why his apprehension is there that if he goes there, since the other persons have also been arrested, including this jeweler, whose shop is near his shop, my lord, so he might also get arrested. So hence this anticipatory bail application.
My lord, here the stolen gold jewelry amounting rupees 30 lakhs, my lord. And lordship, at this stage, his involvement is not found, my lord, but lordship may call for city, my lord. Why he was police is searching his what his involvement, my lord. Lordship may call for city, my lord. Then it will be clear, my lord, from the city.
Just one information. 30 lakhs was
But
the
it is amounting to rupees 30 lakhs.
30 lakhs was the amount which was stolen. But from this Biswanath Saha, lordship will see only 0.113 gram of gold was found. 0.1 gram. And my shop is nearby. At this stage, at least prima facie, there is no allegation against. If CD comes, some material comes, my lordship will reject my bail application. But at this stage, since nothing is there, in fact, my friend is also saying that some protection may be accorded, my lord. So at least I can go and participate in the investigation.
Then application. It is submitted in the list of the forwarding report of
Biswanath sir.
accused Biswanath Shah. Seeing that there's allegation of against said Biswanath Shah of purchasing the melted gold from another person, which was stated to be stolen. But this present petitioner has no connection with said Biswanath Shah. But he also owns a jewelry shop which is situated near to the jewelry shop of said Biswanath Shah. But accordingly, the police is searching for him, for which he has the apprehension of being arrested in connection with this case. He is ready and willing to extend his cooperation if some interim protection is provided. Mr. Sharma, the learned additional PP submitted in history. That from the FI itself, it is seen that the cost of the jewelry is around 30 lakhs, and the present petitioner is also has a jewelry shop. Accordingly, he insisted call for the diary to know the actual facts. Next, considering the interest, I felt find that one chance may be given to the present petitioner to appear before the IR and to cooperate in the investigation. In your business provided. He will be under interim protection. Witness, where you stay?
Nagaon, my lord.
You have to come before
Jorhat, my lord. 10 days time, my lord.
10 days. Within 10 days. Okay.
Deeply oppressed.
Will be listed on 22nd of January.
Deeply.
May it please the Lordship. Lordship, this is 482 application for pre-arrest bail. My lord, there are two FIRs, my lord. One is Bagribari PS case 74 of 2025, wherein the petitioner is praying for bail. Be it mentioned here, my lord, the petitioner's name is not mentioned in the FIR. And the second FIR, Lordship, that is Bagribari PS case 75, both the FIRs are registered in the same day. The second FIR was lodged by the present petitioner, my lord. He was the informant in the second FIR. My lord, first FIR may be seen by this honorable courts at page 10. Page 10, my lord. Only relevant portion may I read, my lord. Page 10. The fifth line, my lord. The accused number 1 attempted to abduct my sister-in-law, Zulekha Bibi, by forcefully dragging her. My lord, with due respect, it is stated that 15/11/2025 at around 12 a.m., the accused persons mentioned below, along with 15 or 16 others, arrived in a four-wheeler vehicle and 3-4 motorcycles. They camped armed and disguised in army uniform and unlawfully entered the house of my elder brother, Moharuddin. The accused number 1 attempted to abduct my sister-in-law, Zulekha Bibi, by forcefully dragging her toward the village road, and arising an alarm, nearby villager rushed to the spot and rescued her by stopping the accused. My lord, this is the relevant portion, lordship, wherein the sister-in-law of the informant was dragged by accused number 1. My lordship, the other aspect, my lord, your lordship will see the accused number 1 and accused number 2 of the first FIR, lordship, they are brutally assaulted by the informant's family. The medical report will reveal, my lord, from page number 25 onwards. Page 25, my lord. That is the discharge certificate of accused number 1, my lord. He was admitted in the Dhubri Medical College. Date of admission is 16/11/2025, and he was discharged on 25/11/2025. For 10 days, he was admitted. My lordship may kindly come to page 27, 28, and 29. How brutally they are beaten up. Their bones are even broken, my lord, and injuries in the head, they are suffering, my lord. And for their brutal assault, my lord, the present petitioner, lordship, he lodged the second FIR, my lord. And this honorable court, after considering the allegations in the first FIR and the injury, this honorable court has already granted interim bail to the named accused also, lordship. Your Lordship will find at page 32, order of this honorable court, granting interim bail to the named accused person, except accused number 1, because there is an allegation in the FIR that accused number 1 tried to drag the sister-in-law of the informant, but other named accused person has already been granted interim bail by this honorable court. My lord, since the present petitioner has lost the second FIR out of grass, they are dragging him in the first FIR, Lordship, although his name is not there in the first FIR. So therefore, at this stage,
First FIR, second FIR means second FIR is lost by you.
lost by me, my lord.
First FIR, second FIR, we are
Cross FIR.
Cross FIR, cross FIR.
Not that.
Pardon me, my lord. The cross FIR is also annexed here in this case, my lord. That your lordship will find that,
So you are the accused number 1.
no, I am not named in the FIR, my lord. Accused number 1 and accused number 2 earlier prayed for bail in this court, lordship, wherein the accused number 2 has already been granted interim bail, my lord. That your lordship will find at page 34. I am the informant in the crossed FIR, lordship, and that is why out of grass, lordship, they are dragging me in the first FIR. Otherwise, my name is also not there. And the allegation in the FIR is very specific.
Why you have lost the your FIR, cross FIR?
Lordship, because my brother, that is accused number 1, who was brutally beaten up, my lord. The medical report I have annexed. I am the brother who has been brutally beaten up.
So who are you? You are the brother.
I am the brother of the injured person. That is accused number 1. I was not even in the place of occurrence, my lord. I have categorically stated. And the allegation in the FIR, my lord, your lordship will find that it is the accused number 1 who tried to abduct the sister-in-law of the informant. The allegation was specific towards the accused number 1 only, my lord.
So why you have the apprehension? You are the only informant in this case. Why you are apprehending it?
My lord, police has arrived at my home, lordship, and they are searching for me, my lord.
Yes.
My lord, here, first of all, lordship may call for CD, my lord. Why they have entered the house at 12 a.m. in the night, my lord, in the house of the, my lord, informant, my lord. Here, although, my lord, 2 names are there, my lord, Ayub Khan Choudhury and Mofidul Haq, but here it is mentioned that 15-16 others and 4 wheelers and 3-4 motorcycles, my lord, and they are in wearing army dress. For what purpose they have entered the house at 12 in night?
My lord,
This is the question, my lord. Thereafter 15-16 number, perhaps they are associates, my lord. Then lordship may call for CD, my lord, and definitely it was interim was granted only to my lord Mofidul Haq, my lord.
Only thing I just want
My
to
lord.
ask you, they have named 2 accused persons.
My lord,
One to definitely tried to drag her, and the other one also there, and they assaulted everyone. And the initial like 2-3 lines of the FIR speaks that 15-16 others were also accompanied in a 3-wheeler or 3-4 motorcycles. So there are a group of people came in. But if the present petitioner was also there, or he attempted or committed anything, suppose they are very much known to this family because they are of same village. May not be 14-15 other people may not be identified, but identification of the present petitioner was very easy, I think. So let him appear before the IOTA in that case. Otherwise, if you see very
my lord, but otherwise, see, offenser, my lord, in
because
seriousness at
serious
12,
in
my lord.
nature, otherwise
At
serious
12
in nature.
in the night, my lord.
12, they arrive, and that apart 15-16 others were also there
Wearing army dress, my lord.
wearing in an army dress.
My lord.
But identification of the present petitioner was so easy for them, I think, but his name has not been mentioned. Only that is the only point of concern. Otherwise, case is of serious in nature. What is the stage of your case? Second FIR? Yes.
That has been registered, my lord. That has been registered as Bagribari PSK 75 of 2020-25, my lord.
And in the FIR lordship, it has been categorically mentioned that the victim, Zulekha Bibi, is having some illicit relationship with the accused number one. It has been categorically mentioned. And that is why the husband of the victim called the accused number one for some social discussion of the dispute arise earlier. It has been also
Social discussion.
social discussion.
Why?
Amicable
His wife is having illicit relationship with
My lord, for
that
the
part social discussion will be there.
my lord, for the relationship, there was a dispute. So they wanted to sort it out, and that part has been already mentioned by this honorable.
Petition, distribution, Tilane additional PP appearing on behalf of state. It's an application, section so and so, section fix so and so. Is submitted by Mr. Karim that the present accused petitioner is no way involved in the alleged offense, and he is not also an academic. However, during that incident, his brother, that is the accused number one in the FIR, was brutally assaulted by the informant and family member, and for which he had to lodge a FIR, cross FIR, which is also registered in Bogribari police. However, as the petitioner had lodged an FIR, the police is also searching for him without any sort of his involvement. Hence, apprehension of being arrested in connection with this case, for which the present petition has been filed seeking the arrest. Next, however, he is ready and willing to act his cooperation in this case if he is granted some interim. Next, Mr. Sharma, Tilane Detention PP submit.
May I please, your lordship? Your lordship, I may be allowed to withdraw this case. With a liberty to file if compliant.
So,
yes,
or otherwise you can submit to an additional affidavit also.
yes, your lordship. I may be
That
allowed
also
to.
can be done.
Yes, yes, yes.
You
Yes.
may file an additional
Yes, your lordship.
Sharma.
Yes.
Mr. Parasar, you are affidavit 2024 as by Learned Assistant Session Judge number 1, Kachar Silchar, in Sessions case number 47 of 2021, convicting the accused appellant under section 376 IPC and sentenced to undergo RI for 8 years with default stipulation. Appeal is admitted for hearing. This year, case record be called for. List matter according immediately after receiving after 4 weeks. List matter 4 weeks, along with criminal appeal number 138 of 2024, which is also arose out of same judgment. Mistake. I don't know. I same to your hearts and so. This is an application, the section 430 PNSS, praying for suspension of sentence passed in the against the present appellant of the applicant in the judgment and order dated 19/3/2024, passed by Granite Assistant Session Judge number 1, Kachar City, in Sessions case number 47, convicting the applicant section 376 Act with deposit. Yet the matter also be listed after 4 weeks, enabling the state respondent to file their affidavit, to file their written objection.
If any manner, it is 8 years.
Can be filed orally also.
Hello.
Please, your lordship. This is a matter in criminal revision petition against an order passed by the principal judge family court at Guwahati, where a maintenance amount was given of 30,000 for the mother and child and for the mother. And however, the date of order was given, date was given from the next month and not from the date of application, which has been mandated by the Rajneesh versus Neha judgment, as you know, your lordship. So basically, my prayer is that one of our prayers is that the maintenance should be paid from the date of application and not from the date of order. Your lordship.
My lord, before my learned friend submits, on merit, we have appeared and I have the instruction to file an affidavit because serious allegations have been made in our petition. So, my lord, may I pray for time to
No, serious allegations against whom?
my lord?
Serious allegations against whom? You.
Against the husband, my lord. The husband. I am for the husband. And
No,
the
see,
petitioner is the
question
wife.
now.
And
Yes, I can understand. But the question is that this is revision petition is filed not by you, but by them, by the wife or the
yes,
petitioner.
we have appeared on
You have appeared. You can file your objection, but if there is suppose any serious allegations where there counter allegations where there, those were already decided, sub-decided, whatever. They are only on the they are only on the fact that
I understand.
the order of maintenance was passed from the date
Yes,
of
my
order.
lord. If
not
your
from the
lordship
date of
desires,
application. That is
I
the
have
only
nothing.
thing.
But only thing that I humbly apprise your lordship that my party has given me instruction to pray for some time to file an
Okay, then
affidavit.
that will be done. That can be accepted. It's okay.
That's all right.
If your lordship is willing to take up,
No, it's okay. If you want to
The
file any
matter
objection,
may be
you can
admitted
file.
today.
You
On
can file.
That's all. Admitted for it.
Well,
Matter
so
may be admitted
We
today.
are going to accommodate you. It's okay.
oh, your
But the
lordship
question
is
is, this
admitting.
allegation, counter allegation, these are not the
Yes.
question of dispute now. These have already been settled.
Yes.
Now order has already been passed. They have come only with the the order was passed not from the date of order, not from the date of application, but from the date of order. That is the only.
Yes, that is on
Yes,
merit.
that's
One more ground she has taken, my lord. One more ground, my learned friend, that see during the pendency of the maintenance proceeding, her appointment was terminated. Her appointment was terminated. That is also one of the grievances. But Honorable Supreme Court, had the aforesaid judgment, has categorically stated that if any such alteration occurs, an amended affidavit could have been filed because the amount she is assailing that it is very little and she has become jobless. That fact was not brought to the notice of the Honorable Trial Court. So how the trial court can be held liable or can be can be held that she failed to take into account that her job was no more. That fact was not brought. So that portion that she has become jobless, Supreme Court has said, Honorable Supreme Court has said that that fact could have been brought to the notice of the trial court by filing an amended affidavit. That was not done. So that is also one of the grievances. That much I have stated.
We are not going to finally hearing the matter today.
Yes, on merit,
Uh,
Lordship will hear.
Okay, then on merit will hear.
I'm obliged, my.
You are Dr.
I'm Dr. N. Borough.
Ranpur, the learned petition. MS Chaudhary, the learned counsel for the respondent. At the request made by MS Chaudhary, the learned counsel for the respondent, the matter is adjourned today, enabling the respondent side to file their affidavit in opposition if any. When your convenient date will be, is there any?
Lordship, there's a little urgency because mother, she's not getting money. She needs the money also because there's several
She's not
litigations.
getting the money.
She's
of
getting the money from June when it's been ordered,
but not from the.
where she's been in continuous rounds of litigation which has been filed by the husband and the child is with her. So we need the money also. So not a long date. After vacation.
I have no objection.
After
Only
vacation.
thing I have difficulty from the second week of February to March.
Lordship, first week of January.
January.
This week. After vacation, your Lordship.
January.
Immediately after vacation. You want a date? Be fixed.
अपने कोर्ट को
Okay, date. After week, my lord. 22nd January. ওটা কেটে দিব। Before Bihu. Before Bihu. On 10th.
10th is Saturday, your Lordship. 10th is Saturday. It's a holiday.
19th is only last working day.
Last working day. Lordship, sometime about 6th or 7th, any date. 7th is 6th.
6 can be. 6th.
Obliged.
6th, okay.
6 matters are yes. Matter admitted. Obliged.
I'm obliged.
In this, in this case, Lordship was pleased to call a report from the Bokista PS. Today, I have not received the report, from Bokista.
Report was called for.
My lord. I prefer short that immediately after vacation.
My lord.
So there was an ossification procedure.
My lord, that is
My lord.
Confiscation.
Oh, sorry, confiscation process. Okay.
My lord. Simple submission, my lord. My lord. 2 times report was called for, but it is not received. Moreover, my lord, the vehicle is keeping in the campus of the outpost of the Zorabad about 6 months, above 6 months, my lord. And this vehicle is now perhaps going to destroy.
Now see, that is understood.
My lord,
That your vehicle, maybe it's a machinery, so there may be damage. We can understand that. But the now question is that the other side is saying that the confiscation proceeding has already been initiated. We don't know. I'm the new one. I'm just seeing the report. Report was called for. So we don't know what is the status of that confiscation proceeding. That much only we require. Otherwise, I can understand that the vehicle is in campus. Maybe there may be a damage also. That can be.
minus
The
2
question
times.
is that what is- no, what is the status of now the ossification? Sorry, the confiscation. That is only required.
Actually, my lord, as per the lower court order, as per court
Because
below,
lower court has passed the order. Sorry, the trial court has passed the order on 13/11/2025 for a direction for the confiscation. So what is the stage of the confiscation? We don't know.
my lord, actually, as per this order, court below passed an order. We have silences that order. As per that order, actually, my lord, the confiscation proceeding is not doing against the vehicle, my lord.
That's why I prefer
Last-
sometime what is the status of
Last part of the last part of the order, my lord. Page number 19. Page number 19, there is mentioned, my lord, last part of the order. Since the fertilizer are presently stored within the seized vehicle themselves, bearing so and so, and due to unavailability of alternative shortage space at Zorabat Outpost campus, the release of the said vehicle of Zimma at this stage is not feasible. My lord, actually, the confiscation proceedings initiated against the fertilizer, my lord, not vehicle. Only keeping the fertilizer,
From where you are saying, from where?
my lord.
From where you are saying that confiscation is only for those
My
fertilizers?
lord, this last part of this order, it is reveals that, my lord.
No, but it doesn't reveal anything.
Man-
There's no nothing. There's a question is that only your petition was rejected because the fertilizers was loaded in your petition, or at this stage that was not feasible for the part of the court
My lord.
for any this Jimma. So that most probably that was the observation. So accordingly it was rejected. But subsequently it has come to the knowledge that there was an order of confiscation. So we don't know from your submission. It is not here. I have not seen anything that the confiscation order is only in respect of the fertilizers,
Mine.
not
Mine.
for the vehicle. It's
Hmm.
not here.
Mine.
That's why we are asking for the report only. Otherwise, how can we pass any order? If
My lord-
confiscation is by that time, if confiscation proceeding is already over, that will be another problem. So
My
that-
lord, two
okay.
times report was
Times,
called.
I don't know. Where two times it was called for.
Bokistam.
Okay, so why you could not punish this?
My lord, today morning also.
Take some steps for.
My lord,
pulling
today
this
morning
record.
also I have also informed the office.
Ah.
They were short that.
Today too, we don't have any other short date. At best, we
My
can-
lord, reopening just
You are Mr. A.S. Ahmed.
Yes, ma'am.
Mr. A.S. Ahmed. Petition. So far, Mr. P. Sharma, the done additional PPA agreement is submitted by Mr. Sharma that he had a telephonic talk with the investigating officer, but it is with the Persistent PS, whereupon it is informed that they need some more time to file the report, which was sought. However, in that context, Mr. Ahmed submitted that the report did not receive in spite of in two occasions, and he also submitted that there is every chance of damage of the vehicle, which is kept open in the police station. In view of this, let the report be called for. A reminder may be issued with the direction to the IO to furnish the report before this court on or before the next day. 7.1 immediately after petition.
6, my lord. 7. I have the difficulty 6. my lord.
Six, now 6 may be a problem because 6 is just opening.
Opening one.
It may not reach also. That's what I.
As a court below, my another case is fixed.
Then maybe on 8.
8.
8.
Obliged.
May I please, your lordship? Lordship,
Well-
CD was
My CDN status report called for, my lord. We have not received today.
CD.
My lord.
You are MS.
AA Chatyaya.
Hard MS AH Patel, the done it constitutive petition. Sudhi Sharma, the done it additional PPA application. CD and status report.
My lord. From
CD and status reports as called for.
Murajar PS.
Call for from Murajar.
Murajar.
Murajar PS is not yet received. Issue reminder. Please. You want any fix it or after vacation?
After
After vacation, this matter accordingly after. But CD is called for, no?
CD call.
So that's why we need Peter to give a date.
My lord, that is also.
In that case, let it be on. Oh, no, it's basically 20.
My
20.
Much okay.
Right, please, your lordship. Okay, this is a POXO case, my lord. And as per office note dated 23/10, 9/12/23, unserved notice has been received back in as no such person at KB, my lord.
KB means Kendriya Vidyalaya.
Kendriya Vidyalaya, ma'am. Maybe dream to a completed service, my lord. Amicus may be appointed.
Why you have given the address of only KB, only the present?
My lord, deeply up.
লম্বা হলে নকল করবে।
May it result. But in this matter, my lord, we have to take fresh steps upon the respondent number 2, my lord.
Why? What the office note says?
My lord,
What office note says?
office note says that, my lord, the earlier steps, my lord, which were taken,
Ah.
the address was not correct, my lord. So we have to take out the fresh address, my lord.
But will you be able to this find out the correct and present address?
That is the
Can
problem,
try.
my lord. We are trying, my lord. I am representing this Assam Industrial Development Corporation, my lord.
Industrial. Try to collect them.
Yes. But the thing is that the matter is fixed before the lower court on 29 January, my lord. So my lord will give us a liberty to pay for adjournment on that day, my lord, like the earlier orders. Because the managing director, my lord, has been issued summons as a witness in that matter. It's a private dispute, my lord. The managing director, my lord, in his official capacity has been made a witness.
So your petitioner is a witness there.
Yes.
He's not an accuser.
No, no. But he
Why
is,
you were there?
but he, well, the summons says that, my lord, it pertains to some notice of the year 2001 when this particular managing director was not in his office, madam. So he does not know anything about that, madam. So we moved that application there that any representative of the office can also produce the documents, not the managing director. So what happened, my lord? Once, my lord, that petition was accepted and the prayer of the complainant was rejected. Second time again, he moved an application saying that we have to issue summons to the managing director. This time, my lord, the order was reviewed. Now, criminal court cannot review an order. The order was reviewed, and then again, summons were issued to the managing director.
Mr. S. Does still done it from petition. But you are the formal party state.
Formal party, formal.
But Mr. R. Kaushik will done it petition PP appearing on the list. From the office note dated 19/8/2025 and returned with a remark 19/25 the notice returned notice issued against the respondent number 2 had returned with a remark the invited command report insufficient evidence. In that context, Mr. Das submitted that he will be permitted to take fresh steps on the respondent number 2 in his present and permanent account. Further, considering the submission made by learned counsel for the petition, it is the further considering the submission made by submission, the petitioner is at liberty to move an adjournment of the adjournment petition before the learned trial court below, if necessary. List accordingly. You want here a fixed date here? After vacation,
After vacation.
immediately after vacation as an edit. Okay, you are giving liberty, otherwise that may be considered also. Okay, then
I hope.
All the three criminal petitions are passed in a common judgment, and all the criminal petitions are hereby stands dismissed. This criminal revision petition stands dismissed.
May I please, your lordship? I'm not feeling well, lordship. I'm appearing in item number 32, respondent, lordship. Petitioner is also present. Kindly pass over for detail. I'm not feeling well, lordship.
What? In IT, you are paying item number 32.
32, I am for the respondent.
Legal aid counsel as a
Yes.
respondent. You are
Petitioner
for
is-
the petitioner? Considering the submission made by MS report the learned legal aid counsel for the respondent. The matter is adjourned. It will be after vacation only. Do you have any fixed date?
That should be fixed.
Fixed date. 19th of January.
Deeply of it.
May I please, your lordship? This is for clubbing of the affairs, your lordship.
You are appearing.
Yes, ma'am.
He was initially arrested, your lordship, on 27th and 2025 in a Dispur police station case, your lordship. We are not seeking clubbing of this case, your lordship, with the others. Then, your lordship, ultimately, your lordship, on 28/10/2025, your lordship, he was arrested by CID police station, your lordship, in connection with an FIR. Your lordship will get it at page 31. It's a long FIR, your lordship. This is against
Page number?
page 31. It starts from the operative part starts at page 34, your lordship. Paragraph wise, your lordship, they have made allegations referred to certain incidents that have taken place in Sibsagar, then Guwahati, para 3, para 4, your lordship will find Naharkatia, then para 5, Jorhat. In fact, your lordship, all over the Assam, the activities of this particular organization has come under scanner, your lordship, or police, your lordship. That is and this is the CID is, your lordship, investigating the larger conspiracy, your lordship. It encompasses, as your lordship has seen from the FIR, entire Assam, your lordship. Now, this was registered on 28/10/2025, your lordship. He was arrested, your lordship, in connection with this case, and your lordship soon arrested, and he is presently under custody, your lordship. Now, your lordship, in the
Initially, he was
meanwhile,
arrested under Dispur PS.
Dispur initially, then soon arrested in connection with this case, your lordship. In the meanwhile, your lordship, series of FIRs has been lodged all over the state, your lordship, and all these FIRs has been lodged, your lordship, on 28/10/2025 or 29/10/2025, your lordship. And all these FIRs, your lordship, mostly, your lordship, these were lodged by police officers, your lordship, making certain general allegations of, your lordship, extortion and demand, unlawful activities, etc., your lordship. Now, your lordship will find that in out of these affairs, your lordship, in Tezpur he was soon arrested, which is at and also in Samaguri he was arrested, and in case in respect of Naga also he was arrested, soon arrested. Now, if your lordship comes to the Samaguri FIR, your lordship will kindly come to page. First, your lordship will kindly come to the FIR page 40. This is in Nagaon, your lords. Allegations are similar, your lords. General allegation regarding activity. Your lordship may kindly see the FIR at page 40. Date, your lordship will note 28/10/2025. An organization, your lordship, which is in existence for nearly 20 years, your lordship, and this petitioner is leading it, your lordship, and there is no arrest, no criminal charge against them, your lordship, at no point of time. Suddenly on 2 days, your lordship, series of affairs with this similar kind of allegation, your lordship. Page 40, your lordship may kindly see.
Yes.
With reference to the subject cited above, I would like to draw your attention to the members of the Lasit Sena, namely Rupjyoti Soika of Dimoroguri, Bitupal Soika, Samaguri, Pankaj Bhai of Dimoroguri, Tolukpa Soika of so-and-so. Some others were allegedly found in some illegal activities at Uria Gaon in the vicinity of Nagaon area. Information received that these members of Lasit Sena, certain local businessmen, commercial estimate trucks, flying through national highway for extorting money for their personal gain in the name of the organization by using various means. Example of such incident which came to notice that on 24/7/2025 at night, some persons coming below vehicle towards those stopped at Uriaga passenger vehicle was assaulted, humiliated in the name of caste and religion. After extorting money from them, the persons were released. Again, another news published that some banners of Durga Puja pandals were destroyed by the members of organization Hatia, thereby creating a communal tensions among the Bengali and other community lying peacefully in the locality. Their local leaders of Nagaon running these entities like extortion and collection of money, bullying to small traders, etc., personal gain, in active support of your lordship, so and so and so and so, your lord. Now, your lordship, all allegations, all affairs are similar in nature, your lordship. Your lordship will find then, your lordship, page 52, Samaguri, your lordship. And your lordship will finally find at page 52, a last line, your lordship. This was also on your lordship 28/10/2025. Now your lordship will find that lastly, your lordship, in last paragraph is page 52, our name has been put. Direction and guidance of so and so, your lordship. Now, your lordship, all affairs are of similar nature, your lordship. Now, my case is, your lordship, that since, your lordship, the larger conspiracy is under investigation by the CID, your lordship, that it is, your lordship, the smaller conspiracies, there cannot have any reason for, your lordship, lodging FIR in every police stations, your lordship, and then arrest him and took him to custody, your lordship, infringing his liberty, your lordship. That cannot be, your lordship. Which Dispur police station case I am not talking about, since there is a specific allegation against certain persons, that's a different matter. But all other affairs, your lordship will see, and there are others also, your lordship, in Sipsagar and other parts, your lordship, that are coming up, your lordship. These are all similar allegations, general allegation against the organization, your lordship. Now, whether there is any material or not, that's a different aspect. I am not on bail, your lordship. We have been arrested by the CBI under custody. They have taken us into custody, me under custody. Now, your lordship, therefore, your lordship, I am praying that all these these other FIRs should be clubbed with this FIR by CID, which is investigating the larger role played in respect of all over the state, Your Lordship. Otherwise, Your Lordship, this will be a violation of my fundamental right, Your Lordship, constitutional right, Your Lordship, liberty. Now, Your Lordship, they have arrested me in this case, then they have taken me to Tezpur, then to Nagaon, then to Samaguri. That is what is happening with me, Your Lordship. And Your Lordship has seen how FIR has been laid. Even in the last FIR, Your Lordship will find they are saying that with my support, it has been done, Your Lordship. And in fact, Your Lordship may kindly take up the BNS for a moment, Your Lordship. 243. There is an indication here, Your Lordship, that it does mean it. Two 243, Your Lordship will find, although it is about trial,
Please anyway, what are talking about? BNS?
243, Your Lordship.
243 BNS.
Your Lordship may take this.
Yes. B is saying BNS.
BNSS, Your Lordship.
BNS we also. Yes.
When a person is accused of more offences than one of the same kind committed within a space of 12 months from the first to the last of such offences, whether in respect of the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 5, Your Lordship. Now, Your Lordship will kindly see the Honorable Apex Court in this judgment have referred to. This is Your Lordship 2025 SCC Online Supreme Court 2080. This, Your Lordship, has got the judgment, Your Lordship. Satyam Adela, Your Lordship. In this judgment, Your Lordship will find that there are para 4. From the record, it is seen that there are crimes registered in the states of Karnataka, Maharashtra, West Bengal, Delhi, Andhra Pradesh, Rajasthan, in addition to Telangana. Multiple affairs within a state is only in Telangana when 4 affairs registered and Maharashtra wherein 2 affairs were registered. Now, Your Lordship will find they have come for Your Lordship clubbing of these affairs, Your Lordship. Now, relying on Your Lordship, Amish Devagan and others, Your Lordship may kindly come to para 9 onwards, Your Lordship. In this context, we also refer to decision in Amanat Ali versus State of Karnataka, wherein also prayer was under Article 32 and 140 consolidation affairs, alleging fraud of a scam carried out by certain company. This court followed the principle laid down in Amish Devagan and invoked the power so to by only permitted consolidation affair registered in the state of Madhya Pradesh. The prayer for transfer of cases pending in state of were specifically rejected. We have also noticed, Your Lordship, para 10. Section 242 of Bharatiya Nagarik Sanraksha Samhita 2023, which enables offences of same kind within a year to be charged together. Section 242 provides that when a person is accused of more offences than one in the same kind committed within a space of 12 months from first to the last of such offences, whether in respect of the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 5. Then, Your Lordship, there is a reference. Then, Your Lordship, finally, the Honorable Court was pleased to club these affairs, Your Lordship. So far as one state is concerned. One state, Your Lordship, in respect of, there will be one affair, Your Lordship. But all over the state, but the affairs registered in other states will not be brought in, Your Lordship, into the particular state. But so far as Telangana 4 affairs, whether it was made one, then state of Maharashtra, it was made one, Your Lordship. And Your Lordship, the another judgment, Your Lordship will kindly see. This is Para 19, Your Lordship, may kindly final direction, Your Lordship. Para 11, the FRS has been in tabular form. FRS were given, Your Lordship, are given. Para 11 to Your Lordship 18. Then para 19, the final directions. The writ petition stands allowed the above term to be further directed, while the first FR will be treated as the first information report. The subsequent efforts in each state shall be treated as statements under 161 of the Criminal Procedure Code. The investigating officer in criminal case arising out of the principal affair in the concerned state will be free to file supplementary charge sheet. That liberty has been given after collection of all records concerning other affairs in the concerned state which are clubbed in terms of this order. We further directed the police report under Section 1 stands already filed in clubbed affairs, and the concerned courts have taken cognizance thereof. Said affairs in criminal cases will also stand transferred and merged clubbed along with principal affair to be proceeded with in accordance with law. Now, in our case also, Your Lordship will kindly see, Your Lordship, that so far as the allegations are concerned, had it been, Your Lordship, they registered by, lodged by different person alleging a specific incident, Your Lordship, then matter would have been different, Your Lordship. The allegations are general in nature. Even the CID FIR, Your Lordship will find a general allegation of extortion and other illegal activities has been made. There is no specific case referred to, Your Lordship. In that view of the matter, Your Lordship, when CID is investigating the matter, Your Lordship, in respect of what the entire state, there cannot have any reason for only for the purpose of their satisfaction to put me behind bar in each case, Your Lordship. That cannot be the idea of lodging FIR, Your Lordship, behind lodging FIR, Your Lordship. That's my humble submission, Your Lordship. I am praying, Your Lordship. Your Lordship may issue notice, let them come up with their affidavit on this point. And in the meanwhile, Your Lordship, I am praying that, Your Lordship, in those cases where he was arrested, Your Lordship, other cases referred to in this present petition, no coercive steps may be taken, Your Lordship. This is my humble prayer, Your Lordship.
Lordships. Now, my lord, the incidents, my lord, in different police stations, whether they are separable from each other, that is the question, my lord. And whether CID is looking after all the FIRs, laws, different police station, man. That's the instruction we have to take, man. And if the incidents are separable, then that cannot be clubbed, man. And moreover, my lord, here CID party will not.
State of Assam party.
CID is also investigating, my lord. So,
Well, three, respondent number 3 is CID.
my lord. Well, at this stage, notice may go, my lord. This investigation is going on, my lord. There is no question of, my lord, stay the investigation. In the meantime, we will file our affidavit, my lord, reply.
The fact that your lordship, they are investigating the offences in respect of the entire state can be goes from their FIR itself, your lordship, a long FIR, your lordship, mentioning about cases at various districts, everything, your lordship, as an example. And what is surprising is the fact, your lordship, that all of a sudden, one day, your lordship, everything came up against this organization, your lordship. One or two affairs, odd affairs, your lordship, in different parts of the state, your lordship, that's a different matter. On the same day, the police get up from slumber and then lodging affairs, your lordship. This is highly unbelievable, your lordship. This shows that there is malice behind lodging of these affairs, your lordship. And that only object is to put this person behind bar on uncertain number of days. Your
Mr. S. Porter, who will learn it constitution. And also heard Mr.
G. Bokolial.
G. Pokolia, the learned government advocate. So made CID as a party also.
Yes,
CID is a
respondent number 3, your lordship.
The other respondents, you are representing in how many respondents? Yeah.
There are 11, I think.
He can, your lordship,
So
appear for.
I can appear for.
you can appear for.
Yes.
So and so appearing, representing all the respondents. So, an application under Article 220 Constitution of India, read with Section 528 of BNSS for issuance of writ in nature, mandamus, and or any other appropriate writ or petitions. It is submitted by Mr. Porter that initially this police station case number was registered against these two petitions. Wherein they got arrested and he is still pending for investigation. As on as subsequently on 28/10/2025, as many as 8 numbers of FIRs has been lodged on 28/10/2025. Similar kind of allegations of corruption and other allegations against the present petitioner, who is the secretary of the organization, namely Sri Lasit Sen. He further submitted that one FIR has already been lodged by if 30, how many 51 year.
Lordship.
This CBI investigated.
CID, your lordship. Lordship.
Was 30. Sorry,
20. 20, your lordship. 20/25.
No. Your pagination, your number is
Lordship 31. (34) onwards, your lordship, the operative part.
commission by the CID, wherein basically allegations of the sticks have been brought and against the present petitioner, which is still under investigation. But apart from lodging the said FIR in different police stations, the same kind of allegations, the FIR has been lodged, bringing the same allegation that under the guidance and direction of the present petition, the other members of the said organization had committed the offense of obstruction. Mr. Next, Mr. Botakur further stress on the provision of 243 BNSS submitted that as the allegations are in general and there is no specific allegation brought against the present petitioner with the any set of separate incident. All the affairs may be clubbed together and maybe in that context, he also cited the decision of Honorable Supreme Court as in case of Ravinder Singh Sidhu, SC1, reported in 2025 SCC online SC 1164 and basically emphasized on para 19 of the pictures pen, wherein similar circumstances that caused the order of clubbing the affairs. Further stated that as the interim measure, the concerned investigating agency may be directed not to take any coercive action against the present petitioner in connection with the other cases. Next, Mr. Gopal, government advocate appearing on behalf of state respondents, submitted in this regard that the case is one case is under the investigation of CID, under CID investigation of CID, but we have to take instructions as to whether the CID is looking after in all the matters, is particularly on the districts wherein the separate FIR has already been lodged against the present petition. More so, he submitted that proper instructions is required as to whether the incident or the cause of action which has been mentioned in the FIR are can be separated or can be clubbed together. Accordingly, he submitted that he needs some time to file his affidavit in position, bringing all the instructions and other relevant matters, bringing all the relevant matters. Next, para hearing this submission made by any council of persons and members of the district, it seen that apparently with these similar kind of allegations, the FIR has been lodged in different police stations, different districts, but without the instruction, proper instruction from the authority concerned. Do not find it efficacious to pass any order on interim relief. In view of this, let the notice be issued and the respondents. However, no formal notice is required to be served on the state respondent, as the government advocate has already represented all the response. Let the matter be accordingly listed. How in which date do you want to submit your?
After we have a question.
In the meanwhile, Your Lordship, they will take custody, Your Lordship, in different.
We'll
That's-
immediately fix a date on maybe on 6th or 7th.
Lord.
Can be
January.
7th of January. Obviously, it will be after vacation. 2 more days. will be
7th
left.
of January reopening date.
No,
No,
reopening date of
reopening
6th.
is in 5th, Your Lord.
Can be on 7th.
7th. One submission my report, my lord. So far as section 240 is concerned, my lord, this is regarding trial. Not investigation.
Pardon, Mr. Popoli submitted that so far provision of section 243 BNSS is concerned, it is only for the trial and not state of investigation.
My lord, requisite
We are listing it
extra
on-
copy maybe.
But-
Requisite extra copies. maybe,
I
sir.
will.
Yeah, that is already there. So you get the requisite extra copies, pick only materials, take the instructions, proper instruction, whether CDI, CID is also investigation, the cases which has registered in different districts in different police stations.
My lord.
That has to be, if it is there in their under their domain or they are looking after the investigation of
yes,
those
ma'am.
cases, then maybe a case of clubbing. Otherwise, I'll see. So we are listing it on 7.
My lord.
10.
This matter, Lordship has dealt with earlier, my lord. 302, my lord. That is why that has come up before your Lordship. Here, what has happened, my lord? To be very precise, my lord, 2 persons are specifically named, my lord. Who have the accused before your Lordship is not specifically named, my lord. Thereafter, Lordship directed that we move the learned lower court below. We tried our luck there, my lord. It was rejected, my lord. Now, primarily, this application is, we are there charge seated, my lord, part charge seated, my lord. When part charge,
Whether your application was anticipatory or
no, regular bail, my
Regular
lord.
bail.
During investigation, my lord.
Acha.
During investigation. Now, what has happened, my lord? They have submitted charge sheet, but further investigation is continuing, my lord. The further investigation, the Rita Chabaria case, my lord, the CBI was a party, my lord. Therein it was said, my lord, that if further investigation continues, my lord, it cannot be a ploy to, my lord, exhaust the clause of default, my lord. Now 187, my lord. The 90-day period, my lord, because it's a 302 case. Now, my lord, my lord, legality, veracity of everything was challenged before the Apex Court. Apex Court said it is good law, my lord. So there are 2 authorities from a High Court, my lord. One much prior hand, my lord, with all respect, my lord, that if further investigation continues and it processes the 90-day period, my lord, if at the inception, my lord, charge sheet is submitted, my lord, then, my lord, the default clause remains. And thereafter, recently, another authority, basically on Ritu Sabaria, after, my lord, the review application has been disposed of by the Apex Court. So, may I just place it, my lord? The date of arrest would be, my lord, have a very, very specific, my lord, 35/25, my lord. This tarikh, my lord, with all respect, my lord, 35/25 that occurs at, my lord,
date of arrest is
Case
30.
20, my lord. My lord,
Your date of arrest is 30.
30, month
five-
is May, my lord, 5. 35/25, my lord, and that is apparent from perusal of page 20, my lord. Is the forwarding report, my lord. So there is no dispute on that, my lord. So the 90-day period is over, my lord. Then charge sheet was submitted, my lord. With all respect, my lord, that occurs at page, my lord, 27, my lord. 27, my lord. 27, 27, 27. 27, my lord. And it was filed, my lord. So during investigation, my lord, with all respect, my lord, it was filed on 31/7/25, my lord. 31/7/25, my lord. Lordship has-
Charge sheet was filed.
Charge sheet was filed, my lord. And thereafter, further investigation continuing, my lord. And when further investigation continues, my lord, Ritu Sabaria was the authority, my lord. I'll read it, my lord. And based on Ritu Sabaria, our High Court has acted on 2 applications, one much earlier, my lord, and one very recent, my lord, 3-4 days back, my lord. May I just place it, my lord, that the default remains alive and we get the privilege of default, my lord, with all respect, my lord.
Yeah, Ritu Sabaria, I am reading out, my lord, with all respect, I am placing it before your lordships. In Ritu Sabaria, my lord, it was challenged by the CBI authorities, my lord, before the Apex Court.
Review.
And Apex Court is a review application, my lord. And the review application has resulted in this, my lord. I'm reading it and placing it before your lordships, my lord. Oh, it is before your lordships, my lord. I'm sorry, my lord, it is before your lordships. IA number so and so is rejected. Lordship may have found, my lord. Having perused the review petition and the connected papers with meticulous care, we do not find any justifiable reason to entertain the review petition. Have I made my position clear? Meaning thereby, Ritu Sabaria is good law, my lord. Have I made my position clear, my lord? Now in Ritu Sabaria, lordship may kindly have a look at para. Para 20, the ratio, my lord. Para 28, my lord. May I read?
Yes.
May I read, with all respect, my lord. Therefore, in light of the above-mentioned discussion, it can be seen that the practice of filing preliminary reports before the enactment, here also preliminary reports, my lord, of the present CRPC has now taken the form of filing charge sheets without actually completing the investigation, only to scuttle the right of default bail. If we are to hold, the charge sheets can be filed without completing the investigation, and the same can be used for prolonging remand. It would in effect negate the purpose of introducing section 167(2). Now, my lord, 187(9). Now 187(9), my lord, with all respect, BNSS, my lord, and ensure that the fundamental rights guaranteed to the accused person is violated. Now, my lord, the exact ratio would be, my lord, 33, my lord. Lordship may have found, my lord. In view of above mentioned discussions, the issues framed by us stand answered as under. The issues were framed, my lord, as to whether the default bail remains alive or not, my lord, without completing the investigation of a KHS charge sheet or prosecution complaint, even if a complaint.
Yes.
I'm sorry, ma'am. A prosecution complaint cannot be filed by an investigating agency only to deprive an arrested accused of his right to default bail under section 167(2) CRPC, now 187(9), my lord. So it remains alive, my lord. And the review filed by the CBI authorities was scuttled by the Apex Court, my lord, with all respect, my lord. Now, basing on this, my lord, one Guwahati High Court authority, my lord, that was way back, my lord. That is, my lord, with all respect, my lord, Samirul Ali, as reported in 2023, 4 GLT 1175. ইয়াৰ কোনখিনি হ'ব ফাইনেল এইখিনি ন এইটো নেকি I'm reading the there, my lord, Ritu Sabaria has quoted second page, my lord, if we turn the page. Samirul, my lord. Lordship may have caught hold of Samirul, my lord. Samirul is our High Court authority, my lord, reported in 23. There, my lord, we turn the page and second paragraph. Learned counsel for the petitioner submits that the petitioners are entitled to get default bail under section 167(2), now 187(9), my lord. Or the call goes on and on and on and on. Honorable Supreme Court in Ritu Sabaria. This much, my lord. Ritu Sabaria, I read out, my lord. Ritu Sabaria is quoted. Thereafter, my lord, the next, my lord, part of the same page, first paragraph, second paragraph, third paragraph. It appears from the record that the present petitioners were arrested on so-and-so and the investigating officer has laid charge sheet on so-and-so. We have given the dates, my lord, in our case, my lord. Have I made my position clear, my lord? And it has been categorically stated in the charge sheet that a said charge sheet is a part charge sheet and final charge sheet would be laid only after collection of FSL report, MBI report and injury report. Have I made my position clear? Same is the case, my lord. Here, my lord, mobile details, my lord. I'll read that line, my lord. And thereafter, my lord, bail was granted, my lord. Have I made my position clear, my lord? The recent authority is only 2 days back, my lord. There, my lord, with all respect, my lord. This BA 39, I'm sorry, my lord. Marked portion should have been with me, my lord. I had placed it before your lordship. Lordship would not take it otherwise, my lord. Because placing before your lordship in a marked manner is not good, my lord. I got, my lord, reviewed one time, my lord. Case number BA number 3994-25. Lordship has seen, my lord. It was disposed of on 11/12/25, as recent as 4 days back, my lord. Therein, my lord, the relevant paragraph is, my lord. There, my lord, Samirul Ali has been quoted, my lord, not Ritu Chabaria. Lordship may have found, my lord, Learned Senior Council has submitted that. Lordship may have found, my lord. The reading of the aforesaid reveals that this was only a part charge sheet and not a charge sheet as required in law. And therefore, even if the same is taken into account, involved the judgment of the court passed in Samirul Ali, so and so. The charge sheet does not extinguish the right to default bail if the investigation is incomplete. Have I made my position clear, my lord? And Lordship may kindly read, my lord, turn back the page, my lord. Last line of the parting paragraph, my lord. The learned so and so for the petitioner submits that
He has further submitted.
he has further submitted that on perusal of the charge sheet with it to show that it mentioned that a few additional evidence report are to be collected and awaited. This is the language, my lord. In the interest of the case, which shall be submitted before the honorable court. Meaning thereby further investigation was continuing, my lord. Have I made my position clear, my lord? In our case, my lord, and here bail was granted on the ground of default, my lord. Have I made my position clear, my lord? Law is settled, my lord. That part charge sheet is submitted, that I am pressing, because the charge sheet is dated, with all respect, my lord. The charge sheet is dated, my lord, with all respect and folded hands, my lord. 31/7, my lord. 31/7, that occurs at page 27. Our lordship has noted down the date, my lord. With all respect, my lord. Here that further investigation is continuing, page 38. If I read, leaving aside 10-12 lines from the top, thereafter, I undertake to submit the FSL report of the seized 4 number.
38, na?
Page 38. Leaving aside 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 13, 14, 15 lines from the top we leave aside, my lord, page 38. Thereafter, I undertake to submit the FSL report of the seized 4 number of mobile phone, DVR along with final post-mortem report and FSL report before this honorable court on receipt of the same on subsequent time, meaning thereby further investigation was continuing. Have I made my position clear, my lord? And thereafter, now what report has come, my lord? This is as late as on 5/10/25 occurs at 16/10/25 occurs at page 45, my lord. It is still on, my lord. Lordship has found, my lord.
Page 45.
Page 45, my lord. Lordship has found, my lord. I will not begin. Learned petition. So PM report reveals that the opinion as to cause of death was supposed to be given after receipt of the chemical examination report and viscera blood so and so, so and so, so and so. Search sheet reveals that 4 number of mobile phone and VCR report were sent to DFSL Kahilipara for forensic examination. However, no report was received at the time of filing of the CS. Have I made my position clear, my lord? Meaning thereby further investigation. Accordingly, the IO is directed to submit the final PM report showing cause of death of the deceased as well as other forensic reports regarding the mobile phone of so and so on or before the next date. Have I made my position clear? Further investigation is still continuing. And thereafter, page 47 is a nail on their coffin, my lord. First paragraph, second paragraph, third paragraph, my lord. This PM report is not what this court directed the IO to submit by order dated 16/10/25. The IO is directed to submit the reports as directed by the order so and so before this court on the next date. Have I made my position clear? Further investigation is still continuing, my lord. So default clause remains, my lord. And on that, my lord, more than 90 days he is in custody, my lord. 2000 and, sorry, my lord, 201 days, my lord. 6 months, 18 days. This is, my lord, nobody can dispute it, my lord, because this is Article 141 authority, my lord. Law as is existing, my lord.
No, but from these orders, it seems that the court is asking to the authority to file their the final PM report. But
Yes.
whether from your charge sheet also, is there any obligation that the case is still pending for the supplementary charge sheet?
Yes, my lord. From that order I read, my lord, this is for your lordships, my lord, whatever we have come to know, that we have placed before your lordship. The charge sheet which was filed on the date in the month of, my lord, with January, February, March, April, May, June, July, my lord. The July dated charge sheet, my lord. Thereafter, no charge sheet has been submitted. With all respect, my lord, with the FSL report and everything, my lord. Apparent, my lord. Because subsequently it has to come, my lord. And it is page 36 is apparent, my lord, if we read it, my lord. May I read again, my lord? Page 36.
Without FSL and without final.
36. Lordship may have found, my lord. Apparent, my lord. Only this was submitted, thereafter no charge sheet has been submitted, no part charge sheet or otherwise. During investigation, the case one mobile phone of the deceased so-and-so and 3 number of mobile phones of so-and-so, so-and-so, so-and-so. In total, 4 numbers of mobile phone were seized and seen before the Honorable Court a letter and forwarded to the same FSL Guwahati. An FSL report is not received at present. During investigation, one DVR was seized and seen before the Honorable Court and later on forwarded the same to FSL Guwahati. An FSL report is not received. Then thereafter, my lord, page 37, my lord. Vikas Setri, it goes on, and sorry, my lord, and thereafter, my lord, page 38 is, my lord, in black and white, my lord. Page 38, leaving aside some lines on the top, I undertake to submit the FSL report of the seized 4 number of mobile phone and DVR along with the final post-mortem report and FSL report before this Honorable Court on receipt of the same on subsequent time. This is further investigation, has to be, my lord. Without that, they submitted charge sheet, my lord. Because it will be an investigation continuing under earlier 173(8), my lord. Now, my lord, with all respect, my lord. Now get the 193(9), my lord.
If you additional evidence report.
In this application disposed of by a coordinate bench, my lord. There, the recent one, my lord, for 2 days back, my lord. There, the part of investigation which was which remain incomplete is stated in the I turned the first page, second page, my lord. He has further submitted that perusal of the charge sheet itself would show that. Have I meant, my lordship may have found, my lord, that it mentioned that a few additional evidence report are to be collected. Additional, have I made my position clear, my lord? Are to be collected and awaited. This is the language, my lord. Awaited the interest of the case which shall be submitted forthwith to the Honorable Court. Here, my lord, police has not submitted. Even court has sought for it. Even thereafter, they are not submitting. And in summary rule, it is clear, my lord. Summary rule, it is clear, my lord. I am reading that paragraph. Summary rule, my lord, it appears from the record that the present petitioner was arrested on so-and-so and the investigating officer has laid charge sheet on so-and-so. Like in our case during investigation. It has been categorically stated in the charge sheet. Part charge sheet meaning thereby, my lord. There are said charge sheet is a part charge sheet and final charge sheet would be laid only after collection of the FSO report, MBI report, injury report. Have I made my position clear, my lord? Here, my lord, all these reports, my lord. There can be no dispute, my lord. They cannot say that final charge sheet has been submitted. That cannot be, my lord.
What? My lord, lordship will look into page 38, my lord, for my learned friend submit, my lord. I undertake to submit the FSL report of the seized 4 numbers of mobile phone and DVR along with the final postmortem report. The final postmortem report was called for by the session court, my lord, and that has already been submitted before the court. It reveals data from the records, my lord. Final postmortem report has already been submitted, my lord, which was called for by the honorable court, my lord, court below, my lord. That has already been submitted. It is in the, my lord, trial court record. If the final postmortem report has been, my lord, submitted, that forensic and laboratory report has been submitted before the honorable court, whether the petitioner is entitled to get the default bail. On merit, my lord, there is a statement of the witnesses is there regarding pointing out the involvement of the petitioner, my lord. That is there, my lord, in the report, record, my lord. And on that basis, my lord, whether it is called, my lord, preliminary in the final search sheet or by supplementary search sheet, or the investigation is to be completed, my lord. But it appears that only the records of postmortem report was called for and the forensic science laboratory report. As the postmortem report, there is nothing, the cause of death is pending. If the cause of death is pending, but in the postmortem report in certain other abrasions and other injuries are there, whether on that basis, my lord, the petitioner is entitled to get the benefit of the bail or not. My lord. Lordship would consider that aspect of the matter. My lord.
Can I just retort to him, my lord?
And my lord, another submission, my lord, page 47, my lord, whether the supplementary search sheet or my lord postmortem report was submitted or not, that was on 11/12/2025. The petitioner has not stated anything what happened on 11/12/2025. If the supplementary cause list or supplementary search sheet or my lord postmortem report has been submitted to the my lord trial court on 11/12/2025, that instruction I don't have at this moment. And if that instruction is there, if that investigation has been completed, all this has been submitted before the trial court, my lord, that is not clear from the petition itself, my lord.
Can I
And the
just
next day, 11/12, my lord, to the 4 days before, my lord.
নবদিন হয়ে না যাব my lord, with all respect, my lord, here the dates are important, my lord. No, one cannot be detained. Have I made my position clear? Ritu Chavaria, my lord. Subsequent to 90 days, my lord. Whether the reports were submitted, as my friend has suggested, my lord, whether it was within 90 days. Am I apparent, my lord? It is mere clear and simple arithmetic, my lord, not even mathematics, my lord. It is to be calculated. Definitely, my lord, the date side, that is why I placed the dates, my lord. Court sought for the report and seeking report, that means it was not received. Further investigation was continuing. Till that day, whether 90-day period was over or not, may I just place the date and calculate it. It's arithmetic, my lord. It's much subsequent to 90 days, my lord. We were arrested on 35. Have I made my position clear, my lord? So 35, then 90-day period would expire, my lord. As is contained even now, my lord, with all respect, my lord, 187, earlier 167. 35, 36, 36 1 month, 37 second month, 38. If it is submitted subsequent to that, because the report seeking by the learned magistrate is much subsequent to 38, that I am reading out, my lord. This is, there cannot be any confusion, my lord. This page 45, my lord. 1610. May I read it, my lord? Learned PP submitted naked. PM report reveals that the opinion so and so, last line, my lord, as well as other forensic report regarding the mobile phone DVR on the next date fixed. Have I made my position clear? Meaning thereby those who are not available before the court, after doing further investigation, police did not submit it prior to, my lord, with all respect, my lord, that 38/25. 38 when bail petitions were pending, my lord. After direction from your lordship's court, my lord. There is no dispute on that, my lord. Now, if it comes, my lord, subsequent to 30 days, it will not do, my lord. There cannot be any dispute, my lord, on that, my lord. If you can reply, my lord, because it is arithmetic, my lord.
He is seeking, he is submitting that at the time of filing of the charge sheet, there was a prayer from the IO that during this course,
Madam.
collect the forensic science laboratory report, PM report, etc., and it will be filed. Now, Mr. Mahajan is submitting that within that statutory period of 90 days,
Exact, my lord.
whether those were submitted or not, whether that can be considered as a charge sheet or not. But he is submitting that the order of 1810 and 1312 or 1311 is must
Subsequent to 90
the
days.
90 days. So in that context, we want to submit it. Because it reveals from your order annexed by in the petition that is on 1610. That was called for by the court as it was not before the court. That means the PM report or the FSL report was not received by
Not
the court
forthcoming
at that time.
At that time, madam.
At that time.
At the time of filing, search sheet, it appears from the search sheet that at the time of filing of the search sheet, those forensic science report was not there and it was submitted later on, madam. But the date is important, my lord, when the forensic science laboratory report was received and it is in the report of the, my lord, trial
So can
report.
you just tell us?
It is there, madam. It is there, madam.
It has to be prior to, my lord, with all respect, my lord. Even as it's
31/7.
38, my lord. 38 or agot hole moi napao.
It is before 2/7/2025.
Just file.
My lord, Forensic Science Laboratory dated 2/7/2025.
No, it is not yet. Clarification বিচাৰিছো ন সেইটো my lord, that was clarification was sought for, my lord, on this.
Forensic Science Laboratory report is there, my lord.
Order dated 16/10/25 clarifies everything, my lord. That it was on record, this report, my lord, in the month of July, my lord. It is apparent on reading the order dated 16/10, my lord. Thereafter, it was sought for. Have I made my position clear, my lord?
So you're saying that result of examination was there
There, my lord.
on 2/7.
My lord, so as the report was not submitted along with the Forensic Science FSL report, my lord, the FSL report is dated 2/7/2025. It may receive subsequently and it was submitted, my lord, to the court when the court asks for it, my lord. Date is there, my lord. FSL report is in the postmortem report. It is written that it is waiting for the FSL report, and FSL report is there, my lord.
On reading the order of 16/10, it is clear, my lord, that this report, the court was seized of the matter, my lord. May I read it, my lord? It would be apparent, my lord. Despite thereafter, it was sought for. It was not complete, my lord.
Just tell us then one thing.
Well,
Because in the charge sheet itself, it is the observation of
My lord.
the IO
My lord.
that he may be permitted to file the
Exactly.
final
My lord.
report and all.
Sought for
So,
a.
yes.
16 cannot be a final report, my lord.
Now, why this was not submitted with the charge sheet then? You
My lord,
2/7/2025.
there may be, my lord, at the time of submission, my lord, at the time of submission of the search sheet on
Because
31/7.
was submitted on 30/07/2025.
1/7/2025. 31, it is date is there, my lord.
Yes,
at page
31/07/2025.
25, my lord.
But in that time, that in the charge sheet itself, there is a note
Their report.
from the IO
My lord.
that they
Report
may
of
be
the
opting this
Forensic
one
Science
and that-
Laboratory was not received. It was there, my lord.
Final report was not received, my lord. That is part. It is written there, my lord, in the
That
order.
the final report, my lord, final report was, my lord, that is date is 2/7/2025. That may be at the time of dispatching, there may be delay in receiving by the IO, my lord. That has not been clarified, but report that trial court record reveals that the Forensic Science Laboratory report is of the date 2/7/2025. That is there, my lord. And which was called for by the trial court, my lord, session court, my lord, and that order dated 16/10/2025, and that was furnished to the court below also, so it is on the record, my lord. So as the matter is seized by the, my lord, session court, the petitioner may approach the session
No,
court
no.
as has already been, your lordship has already passed the order to approach the petitioner to the session court. As the session court is seized of the matter, session court take care of all these things, my lord, and it can be decided by the session court, my lord. And it is only for the
No, you
or the
want to-
pre-trial for charges. Date was fixed for 16/10/2025 for charge, my lord, for framing of charge, my lord. That is the order dated, my lord.
No, this report.
That is
the
a
result
separate
of the
matter.
Examination, when it is been held that there no poison of ethyl alcohol was there. So
my-
that report was accompanied with the charge sheet. Do you want to submit this?
My lord, as I cannot submit more than that, what is in the search sheet. In the search sheet, it is there at the page 38 that I undertake to submit the FSL report. The word is like that way, my lord. If it in the Assamese version, my lord, page 33, my lord.
What it says?
In the Assamese version, 6149 ধাৰাত অপৰাধ ওচৰ মতে মহল তেওঁ পৰৱৰ্তী সময়ত জব্দকৃত মোবাইল ফোন 4খন আৰু ডিভিআৰ FSL ৰিপৰ্ট পালে লগতে ফাইনেল পোষ্টমৰ্টেম ৰিপৰ্ট আৰু FSL ৰিপৰ্ট দুখন পৰৱৰ্তী মহামান্য আদালতত দাখিল
Exactly.
কৰিবৰ বাবে যত্নবান থাকিলো only for submission of the report my lord and the accordingly report was submitted to the court my lord, court below my lord.
When? After filing of the charge sheet or when?
No, that my
Well,
lord,
there is a, if I read, if it is
Please,
read,
sir.
SPC is read, my lord, line to Poridia. Final report has not been submitted. That is there in the order itself, my lord.
Final
Why is wasting court's time, my lord?
I'm
Let him read it.
I'm sitting my lord.
No, no, please
Yeah,
read. Let him read it, my lord. It is apparent. Let me read his lines, my lord. And thereafter I read the learned magistrate's lines. My final charge sheet was not submitted. That is why further investigation was
The
continuing.
word is final postmortem report.
May I read it, my lord? Yes, final
Yes,
postmortem
33.
report. No dispute.
I'm only pointing out that line only. That পৰৱৰ্তী সময়ত postmortem report আৰু FSL report দুখন পৰৱৰ্তী মহামান্য আদালতত পৰৱৰ্তী মহামান্য আদালতত দাখিল কৰিবৰ বাবে যত্নবান থাকিলো প্ৰকাশ থাকে যে ক্লোজ কভাৰ মাৰ্কত সুৱেঞ্চ থাকিল accordingly by the forensic science laboratory report was submitted later on to the honorable court.
No.
That is the factual part my lord. As reveals by the trial court's order. Lordship, I leave it to the lordship will pass the appropriate order.
My lord.
I'm not here for
Trial court's
quarreling.
order, which one? Trial court order is that
11
45.
My lord, is 47. One is 47, one is 45, my lord.
My lord, I'll clarify everything, my lord. No confusion on this count, my lord. Apparent on face of the record, my lord. Final postmortem report was not submitted. Hence, my lord, what the IO has said in Smith. Can I read it, my lord? That report has to be there along with the charge sheet, my lord. Have I made my position clear? It was not final. May I just read it, my lord, in vernacular? So, madam, what he is saying, he is correct. There is no confusion on that, my lord. I also read that. It is mere question of understanding in vernacular, my lord. Taku অসমীয়াত নিজৰ মাতৃভাষাত page 33 মই পঢ়ি দিছো বাইদেউ তাৰপিছত মই কোৰ্টৰ অৰ্ডাৰটো পঢ়ি দিম পৰৱৰ্তী সময়ত meaning thereby further investigation is on পৰৱৰ্তী সময়ত মোৰ জব্দকৃত মোবাইল ফোন 4খন আৰু ডিভিআৰ খনৰ FSL report পালে final postmortem report lordship has found, my lord, whatever was submitted was not final. This is the language. পৰৱৰ্তী সময়ত at a subsequent date prayer by the police. That is why further investigation was on. পৰৱৰ্তী সময়ত মোৰ জব্দকৃত মোবাইল ফোন 4খন 4টা মোবাইল ফোনৰ তেওঁ জব্দ কৰা আৰু ডিভিআৰ খনৰ FSL report পালে when received. Have I made my position clear, my lord? Thereafter লগত ফাইনেল পোষ্টমৰ্টেম ৰিপৰ্ট আৰু FSL ৰিপৰ্ট দুখন পৰৱৰ্তীত মানে কি স্যাৰ এতে সাবসিকুৱেন্ট ডেট হেভ আই মেড মাই পজিশন ক্লিয়াৰ আৰে অসমীয়াটোতে ক্লিয়াৰ দেখোন নিজৰ মাতৃভাষা তাত কি কনফিউজন আছে পৰৱৰ্তী মহামান্য আদালতত দাখিল কৰিবৰ বাবে যত্নবান থাকিলো এম আই কাৰেক্ট পৰৱৰ্তী সময়ত he will sub and kindly see now let me read the co-jointly the magistrate's order. Sorry my lord, session judge's order 16/10/25. Exactly the same thing is reflected. Where is the question of confusion? Second paragraph, the learned PPS submitted that the IOE is yet to submit same language, my lord, in English final postmortem report. Have I made my position clear? Partial postmortem report was submitted along with the charge sheet. Have I made my position clear? That is on record. No dispute on that. But further investigation is continuing. Like the earlier case I quoted, my lord. He is yet to submit the final postmortem report showing cause of death of deceased before this court. Cause of death was not clear by reading that partial report. Have I made my position clear? Thereafter, the last line. Kindly see. Second paragraph, apparent, my lord, search sheet reveals that have I made my position clear? Part search sheet meaning thereby, reveals that 4 number of mobile phones and 1 DVR were sent to DFSL, Directorate of Forensic Science Laboratory, Kahilipara, for forensic examination. However, no report was received at the time of filing of the CS. Meaning thereby, when part charge sheet was filed, those were not available, correct? There cannot be, language cannot be clearer than this, my lord. Thereafter, accordingly, the IO is directed to submit the final PM report. That means the final PM report was not available on 16/10. Partial report was submitted along with the charge sheet that is dated 31/7. Have I made my position? Is there any dispute on that?
Okay, I'll pass you. Okay.
And that is PP's submission, my lord.
For the learned trial.
Before the learned trial court, not the defense submission, my lord. All right, my lord. May I please your lordship? My lord, this IA criminal file before your lordship by the applicant who is, my lord, convicted and his appeal is admitted and pending. LCR is also received, my lord. My lord, in the meantime, what happened, my lord? The impugned judgment passed in on 27/9/24, which is impugned and appeal is admitted, my lord. After filing, my lord, therefore they filed a, my lord, the bail application, my lord, IA criminal for bail, my lord, which was rejected on, my lord, my lord, 2/9/2025.
When your father died?
My lord, on, my lord, 22/11, my lord, page 7, my lord, kindly see. Mother, my lord. I am the only son, and my father is not there, my lord. Father long expired, and I am the only son, my lord. Kindly see page 7, my lord. Paragraph. My lord.
That is okay. It's your submission and other in one burial certificate you give.
Yes, my lord. And my lord, the certificate, kindly the last finally see the page 34, my lord. The death certificate, my lord, page 34, my lord, is issued on 3/12/2025, my lord. And the burial certificate is at page 36, my lord. Page 36, the burial certificate, my lord, this is the next, my lord.
Basically, when your mother died,
My lord, on 22/11, my lord.
then every religious thing is already
No, my lord.
gone.
No, my lord. That is, my lord, on 40th day it happens. The main part is on 40th day, and Fatiha, then, my lord, community gathering, it takes on 40th mainly. And it is mandatory, my lord. I have
He is,
next.
in which jail now?
My lord, Dhubli Central Jail, my lord.
Dhubli Central Jail.
Yes, my lord. My lord, in this regard, may I place a judgment of the Delhi High Court, my lord, squarely covers, my lord, my lord. In the here case, the father expired, and here the elder son, my lord. And here I am the only son, my lord, and there is none other than me, my lord. And only because, my lord, when the bail was rejected, she could not, my lord, tolerate, my lord. Sorry, my lord, it is marked, my lord, highlighted the main part, my lord. Kindly excuse me for this. Kindly have a look, my lord. Due to brain stroke, my lord, she herself came to.
Now see, Mr. Sutia, the question is that he is seeking parole. Now the parole question is a bit different. So if suppose on one day itself, he can go
My lord, again
attend
come
the
back, my lord.
function and then come
back, my
with
lord.
that main other aspect. But parole for how many days?
My lord, we paid for 40 days, my lord.
It's not ever possible. He will never come.
My lord, for
His
similarly.
earlier bail application was also rejected.
My lord.
Uh,
Final, if the record is coming, lordship may fix it for hearing, my lord,
My lord,
final hearing, it can be decided.
My lord, till then it will be over, my lord. Time will be over. That's why, my lord. The application is there, my lord.
that will be different.
Due to vacation.
So now it's in one hand you are saying that your mother died on
22/11.
22/11.
My lord.
Mother-
So
mother-
within 40 days. Now, another hand, he was seeking for 40 days parole. He is not a convict, na?
My lord,
He
for
is
eight,
not
my
a
lord,
convict.
yes, my lord, eight, yes,
His
my lord.
case is still pending, I think.
My
No,
lord-
no, he's a convict.
Yes,
Sorry.
that's
Ah,
so unquestionably, my lord.
Convict, but the question of parole in that stage, in that ground, I don't know. if
But
it could be a-
he may take that ground in the court, but the trial court also matlab, for going to for on payroll for for a particular
My
weekend,
lord-
matlab, for attending that function. He can submit an application there also, my lord. It
My-
can be considered there.
My lord, even the apex court, various high courts, my lord, even the hardened criminal, life imprisonment in convict also may granted, my lord, saying that under section
Parole is a
21.
different set of rules.
Yes, my lord.
It's a different
Conditions,
game.
conditions are there, my lord.
Ah,
Conditions are
there
there.
are, these are paroles are be considered to be by the DGP, the police, prison, IG prisons. These are,
Submit an application.
these are several
Well, I would-
applications, these are
that-
procedural thing. It cannot be just simply grant you on parole on 40 days by the High Court. That is not the case.
My lord, direction can be given to the jailer, my lord, only, my lord, my lord.
No,
We have filed it, my
for
lord.
parole, there are several things are there. Your conduct, your thing, everything has to be looked at. It's not a case that you are going for parole. Yes, for one day you go and attend your funeral ceremony with the, I mean, in presence of the jail authority or in presence of the police person, that is different. But parole is different. That
My lord,
if you want to fix it on, then let it be fixed on immediately on 6th.
my lord,
Immediately on a reopening day.
my lord, maybe on day after tomorrow, my lord, because
No,
my lord,
day after, we are not in a position where I'm going to rise down because there are lots of matters have been pending. 6th corridor.
my lord, Article 21 also, my lord, Supreme Court says that his right, my lord, the fundamental right of
Obviously,
dignity,
right.
my
But
lord.
this rule and set of rules of for the parole will be different. That's what I'm saying. It's quite different. It is not a case that you go and attend the funeral. That can be done. That can be even by loan trial court for the humanity ground. That we are also doing that.
My lord, in
You
this,
can attend the
the
function.
judgment,
You
the
can
judgment
attend that.
before place your lordship 4 is granted, my lord. Right? The judgment before your lordship, 4 is granted, my lord.
That is the Delhi High Court. 6
On 6th.
6 1. This one.
7th of November, Tuesday.
7. My lord,
7th.
আপনি কোন-
What me could do? 6 to my hearing very एक को ना कुछ
হয়, হয়, আমি দেখি কইছি।
7th হলে মত দিতে হবে
7th Wednesday.
6 কি 6
My lord, for report, my lord, what, my lord, for instruction, my lord. My lord, for hearing or for instructions, my lord.
No, you can take instruction. What kind of instruction you will take? For final hearing.
My lord, if any instruction is required, my lord, kindly, my lord, he may be asked for anything from jail you want to place. If he wants, my lord, if my learned friend wants to place anything before your lordship, my lord, then again, if you ask for time, my lord, it will take.
an idea that hearing
No, go for hearing, Mr. Sutia. The
my lord
question is that.
final hearing my lord it can be hard my lord it can be disposed of on that
Disposed
my
of,
lord.
okay.
Obliged, my lord.
6.
May I please, your lordship, now this matter relates to my quashing of FIR. My lord, this matter relates to quashing of FIR, my lord, where section 376, as well as section 8 of the POCSO is involved. Already, court has directed the petitioner to take steps on that's one number 2. We have taken steps on 4 occasions, but as per report available in the stone, my lord, that informant was not found most probably. So, may I pray the lordship that one amicus curiae may be appointed in that case, my lord.
No, my lord. After service complete, my lord, completion of service, my lord.
Service actually completed, I think.
No, service not.
It was
Service
through,
completed, but
the
through police,
jurisdictional
yes, police station, my lord. And that report is also there that they have
You
been not
have the
found.
report.
My lord, not today, not. my lord.
Not found, my lord. Informant is not found, my lord. That is the report.
Address could not be found. It is your permanent address or this is
As
your.
per the address given in the FIR, my lord, that is the address we have furnished, my lord.
My lord.
Address given in the FIR.
FIR, my lord. Other address, I don't know if it was.
Now, do you have any instruction in that?
No.
Because it has been routed through your office,
My lord.
public prosecutor. That has already been done, I think.
On 4 occasions.
Your office has also received
My lord.
the notice.
Then I will have to take.
But now as per there is a last report.
My lord.
The office note The service report in respect of respondent number 2 has been received back from OC Mikil Veta. Okay, Mori column.
Then
As per the report, the could not address could not be found.
Madam.
Let us amicus be appointed, otherwise it will be
No,
deleted.
it will, you mean
It's a
like the
case of washing,
washing, ma'am.
case of POXO.
POXO is also involved, ma'am, that is section 8, my lord. That is why it's there, my lord. And 376 also there, my lord.
Apart Mr. I take a different petition. Apart Mr. B. Sharma, the learned additional BP appearing on behalf of state respondent. As per office note dated 26/11/2025. Service report in respect of respondent number 2 has returned back with a note that addressee is not found in the given address, which is received from the OC of Morikolong PS. In view of this, let an amicus be appointed to represent the respondent number 2. Accordingly, it will be, say, the division bench, it will be a single bench. By appoint Mr. S. Sarfraz Nawaz as an amicus to represent the respondent number 2. The registry will do the needful. List the matter accordingly in admission column on immediately after vacation as an date to fixed by the registry.
25.
Must move.
That is your lordship. My lord, in this criminal appeal, steps is taken, my lord. Both respondent number 1 and 2, my lord, and most probably service report is complete, my lord. And this
service is completed.
My lord, completed it, steps is taken.
Huh? Steps taken.
And LCR
service is there. Service is completed.
Yes,
Seems
my
to.
And LCR,
Not received, madam. In the office note that is.
LCR not yet received.
Madam.
my lord, there is another appeal, my lord. There are several appeal and my lord in this judgment, my lord. One is
Just tell us the appeal number.
yes, another Siam Sri second.
No, number is.
No, number.
Yes, my lord,
Number.
Number.
Any appeal is pending.
Yes. One co-accused Siam Lakhowar alias Paglu and another has already approached before this honorable court by criminal appeal number 106/2024.
106/2024
and that is pending with LCR number 101.
No, whatever, it is pending.
Yes, my lord.
Therein LCR has already
LCR is attached with that criminal appeal, my lord. In connection
the
of
case
this.
under section 370.
This
My
case
case
is, my
not
lord,
required
it's
to
a-
be compared.
My lord, please say.
This is case, my lord, under section 363, added section 195A/370 IPC, read with section 14 of the Child Labor Prohibition and Regulation.
Partner MS PR Sultana, the learned counsel. Yep. Establishment of the additional PP. The office note reveals that the service is completed on respondent number 2. However, no one has represented the respondent number. The scan copy has not yet received. Issue reminder. Further, considering the submission made by MS Sultana, let the present appeal be listed along with criminal appeal number 106 of the.
That is
Matter
also
will
jail.
be-
106.
Yes, jail appeal, my lord.
106 jail. 106 also jail.
106 jail.
Jail.
Jail to appeal হবে না?
But you are legal aid here or you are a council appointed?
I am legal aid, my lord,
You are legal aid?
legal aid.
Legal aid. Legal aid. No, 106 J Niki, jail appeal.
Jail appeal.
106.
Huh?
Yes, my lord.
106 is also jail appeal.
Jail appeal, my lord.
106 J. Probably yes. Okay, we're listing it after vacation along with criminal appeal 106 J.
Yes,
J
my lord. Yes,
2020.
my lord. Another prayer is that one IA, my lord, in favor, in connection for suspension of this sentence, my lord, in this appeal, my
You
lord.
have already filed here.
It is already filed. It is filing number 11636/25. My lord, it is not combined with this appeal, my lord. So may direction may be given to attach this criminal IA criminal with this criminal appeal, my lord. Number is registration number, filing number is there.
Listed. It will come.
Miss Masamlas. My lord, that may be fixed, my lord.
After vacation. Yeah, along with criminal appeals. Well.
26.
None appears on call for the petition. Mr. Bishop, the land petition. This statement according as we did to
27.
Yeah, please note it. But if we have taken the steps today. And
today only.
Yes, and interim order passed earlier may be continued.
Step second today, interim order. What are you saying? No.
Interim order passed earlier may be continued.
Oh, you're pressing on interim order. You have not taken steps today only.
Yes, Mercy, we have
So the
taken.
order of taking steps was passed on 5/11/2024. No steps has been taken.
Yes, steps has been taken, Your Lordship. I have
When?
the
Today?
acknowledgement
Today?
from, yes, Lordship, today. Yes, Lord.
You are Mr.
G. Boro, on behalf of DG.
Heard Mr. G. Boro, appearing on behalf of Mr. DJ Harvey, the Learned Counsel for the petitioner. State is not here. From office note dated 25/11/2025, it's seen that no steps has been taken for the sole respondent. Full stop. However, it is submitted by Mr. Boro that they have taken steps today. Today for issuance of notice to the sole respondent. Let the service be awaited till next date of listing. List the matter immediate after vacation as on a date to be fixed by the registry. Interim order be continued till next date of listing.
28.
As for office note dated, my lord, 1/11/2025, service yet to be completed, my lord. Well, address mentioned in the type challenge the maintenance petition, my lord, by way of quashing petition, my lord. And evidence
So
is
do you have any source for collecting any new present or proper address?
no, my lord, that the address mentioned in the maintenance petition, my lord, same address was given, my lord, this present petition, my lord. They willfully neglected, my lord, I think.
There has to be something. Na,
Yes, my lord. Last occasion, my lord, in family court, my lord, within court campus, my lord, they were fighting, my lord. This respondent to hit, my lord, this present petition, my lord. And this complaint was also filed.
You are your husband?
Yes, my lord.
Oh, then to definitely.
My lord, kindly see the order. My lord, kindly see the latest order receipt, my lord.
No, latest order is okay. I'm not from
Service complete or not that.
Time also.
My lord.
Now the question is that if you want to, will it be possible for you to serve notice in the court itself before the court? If it is possible, then you can serve there also.
Yes, my lord.
If council receives or the Kahi receive, otherwise the same problem will be there.
The next date is fixed for 28/1/2026, my lord. Date may be fixed, my lord.
After that.
Before 28, my lord, date may be fixed, my lord. I will try, my lord.
So you have taken steps for fresh notice also, na?
Yes, my lord.
Mr. P. Sharma, the Secretary, Additional Public Prosecutor for the State of Assam. Office note dated 1/11/2025, Civil State Services. Still awaited for the respondent number 2. To whom, respondent number 2, to whom the, upon whom the fresh notice was issued. And that Mr. Borgo, the counsel for the petitioner, submitted in this record that the petitioner, the respondent is appearing before the, before which court?
Family court.
Family court.
Kamrup Metro.
Kamrup, Family court, Kamrup Metro, but she is avoiding the process from this. Mr. Bora, however, submitted that he may make an effort to serve the notice to the respondent in the court premises of the family court. Let the service be awaited accordingly. You want to fix it after
Yes, ma'am.
28/1?
Before 28, my lord.
Before 28, can it be possible for you to serve the notice?
Yes, my lord.
You are saying that you may take a chance. or you
I'll
can-
contact the advocate of the Noina Setia, respondent 2, my lord. I know him, my lord.
No, it's okay. No, my question is that whether if I give you a date prior to 28/1.
Yes, my lord.
Then
Because-
what will, so how the purpose will serve? Because you are saying that you may take a chance to serve the notice in the court premises on the court on the date fixed. Then
Thank you.
better to take 2 or 3 days subsequent to 28/1, I think.
Yes, my
That
lord.
will, that may serve your purpose. That's what I'm saying.
Highly obliged, ma'am.
Because in that process, you may serve this also, or in that regard, it may come return back to our court. Also.
Yeah, go to the
February
meeting
month,
room.
because 28/1 of this. 3rd of February will.
3rd of highly obliged, ma'am.
The order dated 4/9/25, my lord. The PP had to take steps on the phone number. Steps have been taken through the office of the PP. That report has to come.
Yes,
But
what is your
who is it?
instruction? What is your instruction?
My lord, not receive any information, my lord, at present.
What is this fully? What are they?
There is an office note on 25/6/2025 that your office has already received the note. And thereafter, there is no note.
Means that
note
there is no, I have checked it, but there is no note.
Ah.
Only thing is that
Just take instruction because this is your office has received the notice on 25/6/2000, almost about 6 months prior from the date of today. Just take instructions. Department says, V. Sharma, the learned additional PP, appearing on check respondent. The public prosecutor, the Mr. Sharma, the additional PP, they have directed to take the necessary instructions in regard to service of notice on the respond number 2. As it reveals from the office note dated 25/6/2025 that the office of the public prosecutor had received the notice issued to the respondent through jurisdiction, which is to be sent through jurisdiction police station. List the matter accordingly after vacation. You want any fixed date here? After vacation?
after
After vacation, as a date to be fixed by the registry. Okay, take instruction. That
My lord, my lord.
problem. May I please, Lordship?
Lordship, this case pertaining to quashing of the entire criminal proceeding in NI case numbers, my lord, 769/2024 under section 138, pending before the learned CGM Kamrup Metro.
It's okay, what the office
Lord,
note say?
and this order passed by this honorable court also communicated to the land court below, even though my lord, the trial court.
No, notice is still awaited, I think, na?
Lordship, but it deemed to be served.
And a case record is received.
Deemed to be
Case
served.
received, no.
NI
And case.
Lordship, page 22, the whatever address appear in the complaint petition, that is also reflected in our complaint in this case, madam. So when notice served to the correct address as per CC Allabi Haji case concerned, so it deemed to be served, service deemed to be completed, but because so far page 22, the complaint petition, the complaint address, and so far our this criminal petition, his address found identical, same. So the correct address, the notice was served by registered post. So it is.
Office note is there.
Office note says that AD has yet not returned. So it deemed to
Await for service.
It is still awaited for service. You take steps through speed post, otherwise, because
No,
nowadays
already on a trial court, it is communicated. So far the order passed with this honorable court, that has already been furnished before the trial court. And it is a state of evidence. They know the fact. By knowing the fact, they are not appearing. Already
Whatever, now
communicated
see,
by
the question is
by
that now-
of my letter, by of petition. This order passed by the honorable court has communicated to the trial court, even though the trial court report record has yet not received.
No, we will call for the
That is
trial court
the
record.
that is
That will be done.
otherwise there is a very fit case to quash. Because so far NI concerned not attracted.
Whatever.
130 is not.
Now, see, the question is that this service is still awaited at this stage.
Yes, ma'am. Eddie
So
has not
one
returned.
is that you can take steps through speed post, fresh steps, one aspect, and another, because it is a criminal petition, you can take steps through your jurisdiction police station also. That may be another aspect, two aspects. Otherwise, you are saying that it is been communicated, and that apart will call for the case record, no issue. We'll call for the case record. But
All for the trial
but
court-
you have to take
trial court
steps,
record.
please. Hard Mr. K. We are done it for the petition.
And I have a lordship interim period that has yet not
Mr.
allowed.
P. Sharma, the learned additional PP, appearing on behalf of said respondent. Office note dated 12/8/2025 reveals that neither the AD card nor the unsub notice issued on the respondent number is received back by the section. In view of this, the petitioner is hereby directed to take fresh steps on the respondent through speed post and as usual process. And the petitioner is also at liberty to take fresh steps on the respondent through jurisdiction police station. Further, the registry is hereby directed to issue reminder calling the case record of NI case number 769 of 2024, and the learned trial court below may be directed to send the case record on or before the next date of listing. Please the matter accordingly after vacation, or you want any date?
After vacation. Immediately, madam.
No, you want a fixed date here, or after vacation will do?
After vacation.
Immediately after vacation.
And worship, there is an interim prayer, well, that has not yet been allowed.
No.
Interim prayer.
No.
Because we take the step to the correct address, and despite receiving the notice, they have yet
That
not
cannot be
entered.
the ground for entertaining your intent. And abuse. One she is.
Please, your lordship, 31, item 31. Lordship, steps have been taken twice, but twice the steps was not completed. The lordship, it's a humble request, lordship, if the lordship allows through the Dusty services, will be highly obliged.
Dusty.
Lordship. That's it.
Dusty is not. How, in which process you have taken steps?
Through registered post.
to register post. This time you take
Speed post
state
also, register post already over.
maybe
Speed post.
speed post or through judicial police station.
Officer in
That
charge.
may be officer in
Lord,
charge.
Lordship, and the interim may be continued, Lordship.
Interim was there earlier.
Yes, yes.
That will be continued. Your case diary is not received, na?
But here, two case diaries were called for, my lord, as per earlier
Case
order, my
diaries,
lord.
yes,
My lord.
yes.
Dispur 1235 and Dispur 1040. Well, here I have received one report, my lord. Here it is said that 1235 of 2024, it was FR submit.
What?
FR submit.
FR already submitted.
That report is already available in our record. Only saved today.
You are MS?
Mayuri Bhuyan, M. Bhuyan.
RMS M. Bhuyan did not it. Petition. And also Mr. B. Sharma. Learned additional PP appearing on behalf of said respondent. From the office note dated 27/11/2025, the scene that service is still awaiting for response. In the context, the petitioner hereby asked to take fresh steps on the respond number to speed post and also can take steps to officer in charge of jurisdiction police station. Further, it is submitted by Mr. Sharma that the
Up to date CD in 1040 that was not received, my lord.
dated case diary of
Dispur PS
Dispur PS
1040.
number 1040 is not received. However, one report is received from Dispur police station in connection with Dispur
Dispur PS case number 1235 of 2024.
2024 that FR has already been submitted in the same case. Let the updated case diary of Dispur PS case number 1040 be called.
Well,
list accordingly after petition. If we want to have to fix a date, I think, na?
my lord.
21 Koido 21 1 20 21 21 1 2026 interim be continued till next date of this.
My lord, 21 1.
21 101.
My lord.
Highly obliged, Your Honor.
May I please your lordship? Lordship, as per office note dated 15/7/2025, service of notice upon respondent number 2 is awaited, lordship.
Respondent number 2.
Lordship, I have been informed that the respondent number 2 is presently posted at the office of Deputy Commissioner Jorhat, lordship,
Then they will have to take
as
steps in
District Development Commissioner. Lordship, this FIR was watched by him in his official capacity earlier.
No, who about whom you are saying that respondent number 2?
Respondent number 2, lordship. Lordship, he is presently posted
file under the official capacity, but
yes,
he has been named personally.
Yes, lordship,
personal
because
saying he-
since he was the informant in the app, since
So
he was the-
whatever, when
by
he is
name,
by person, by name, then though obviously
my lord.
no way out. Otherwise, he could have been represented by the state council.
Government advocate.
But now
Yeah.
at present it cannot be. That's what.
Lordship,
So now you are saying that he is presently posted at Office of the Deputy Commissioner in Jorhat
Jorhat as District Development Commissioner.
as District
Development Commissioner.
Development Commissioner.
Lordship, I may be allowed to take steps at Jorhat, lordship.
You are Mr.
S. Paul. On
Part
behalf of
Mr. S. Paul Kidanet. No, your name is also learn from the petitioner. That is petition. From the office note, it reveals that the service is still awaited for the response number 2. Response number 2. In that context, Mr. Paul further submitted that as per their instructions, the response number 2 is presently posted in Office of the Deputy Commissioner Jorhat as District Development Commissioner. Accordingly, he submitted, he may be allowed to take fresh steps in his new and present address, present official address. Prayer allowed. Petitioner will take steps accordingly. We have this is any record was called for here? No.
Yes, lordship. LCR is already received.
LCR is already received.
Already received, lordship.
SJ has already, well, SJ, it's, I say no, SJ. SJ has already
No,
been
no,
received, right?
There is there.
There is. Trial court.
SJ has already been received. So we're listing it after vacation.
The lordship, a date may be fixed, Lordship, if
You
possible.
want your date?
Yes. As per the convenience of this court, Lordship.
27 of January.
27 January. Much of it.
May it please your lordship. Well, this is a criminal petition matter. We have challenged.
My lord, before starting my colleague, my lord, as per office note, my lord, 15/12/2025.
Oh.
Service report is awaited.
Today is fixed, madam. The fixed date, madam.
Fixed date means?
Matter was fixed today, madam, 17/12.
Yes, yes.
Yes.
Matter is
Yes,
fixed.
yes. We have taken steps, my lord, upon the respondent, madam. And lords, may kindly see the last order.
Scan copy record
Scan
is already received
Yes.
or no? Received.
Basically, my lord, we have filed this petition, my lord.
Neither, but service
My
is
lord,
still
service report
awaited.
awaited.
Yes.
Service report is awaited.
Yes.
Want to submit anything?
Just only interim prayer, madam. Interim prayer is there, madam.
We're not going to pass it.
My lord, on the last date, my lord, it has been mentioned that interim prayer will be considered today.
No,
A small issue, my lord.
Heard Mr. Esther still on a consultative petition.
Then lordship will kindly consider one thing, my lord. Kindly consider one thing, my lord. There are 4 petitioners, my lord. 3 petitioners, my lord, have already appeared. Against the 4th petitioner, my lord, NBW has been issued, my lord. It is pending, my lord. Against the 4th petitioner, my lord. If that can be stayed, my lord. Because next date for appearance is on 27 January.
No, in that case, it will be, in the other way, it will be a interim relief or stay. That can.
Then matter may be.
Why the case is, your summons has been issued to against you because 3 petitioners have already been appeared.
Appeared.
No, 1 remains.
1 remains.
Why he is not appearing? It's
Well,
a
he
case of
wants to-
summon procedure case or what kind of
But
case?
he wants to appear. It
Then
is,
let him
my lord,
appear.
He wants to appear, but by the time NBW has already been issued, my lord. And we are against the entire search sheet as well as the FIR. Basically, this case is.
So against him, the NBW is pending.
Yes, it's a counter case, my lord. The first case which we had lodged, my lord, the accused in the first case, he had pleaded guilty. He voluntarily pleaded guilty and he was convicted. This is the FIR, my lord, which was registered against us. It's a counter case, my lord. So that we are challenging.
Now, obviously, that may
Yes.
be a good ground for your
Yes.
pushing and all.
Yes,
But
yes.
the question is that, as in the first date, was NBW was not stayed, so it will be a kind of same again interim case, interim relief matter.
So lordship will fix it after vacation, my lord, before 27.
Before 27. we'll
Yes,
fix it.
any date now.
And what about the respondent number 2? What is going to do in that case?
We've taken steps, my lord. Service is not.
Steps you have taken.
Yes.
I think it's
Lordship, may
still-
kindly 15/12, my lord. 15/12.
Yes.
Neither ID card nor.
It is still awaited, and you've
Yes.
taken steps much. Because you have taken steps.
Yes, immediately
Yeah, no,
after the
immediately after the- but the
last date we had
it's
taken
still
steps.
awaited. This time you do one thing. Within 2 days, you take fresh steps to the respondent number 2 through officer in charge of jurisdiction police station. Let us try.
My lord.
Respondent number 2. In the meantime, we are fixing it prior to 27.
Yes, yes.
So that one cannot do. Mr. Esther still under consideration. From the office note dated 15/12/2025, it is seen that service is still awaited for the respondent number 2, though the scan copy of the DCI has already been received. Considering the next paragraph, considering the submission made by learned counsel petitioner, let fresh steps be taken to the respondent number 2, and notice may be issued to officer in charge of the jurisdiction police station. Further, full stop, let the matter be accordingly listed on এটা 27 or আগত এটা দিন
20 বা 21, 20 or 21?
20 20
20.
20
Hello.
6.
May I please allow? So office note dated 15/12/25. My lord, this service is not complete, neither AD or my lord answer notice. Upon respond number 2.
service is still awaited
Yeah,
at
wait,
our office.
I will.
As per office note dated 15/12/2025. The service is still awaited the response number 2.
Record, whether record call for.
No, record was
whether-
also not called.
Not for
No.
Certificate.
it's further submitted.
For quashing.
Then counsel for the petitioner that the record was not called for. It is the case is charted one.
Yes, for quashing.
They have challenged the search sheet, my FIN search.
Acha. Accordingly, the TCR be called. Scan copy of the TCR be called for. A paste you will do the needful. You are on interim, I think.
Interim order may contain it.
List the matter accordingly 27/1/2026. Interim be continued till next evidence.
Whether they
Take
have
steps
to-
with officer in charge of jurisdiction police station. That may serve the purpose.
Problem.
Great.
We have
May-
entered appearance on behalf of respondent number 2.
Respond number 2.
Yesterday, we have filed our wakalat.
Yesterday you have filed your vocal.
Yes.
My lord, there is a stay order. That stay order may kindly be continued. Order was on 24/11.
So you are the sole respond number 2, na? You are?
Yes, Lord.
You are Mr. A.K. Jain.
I'm AKJ.
Heard Mr. A.K. Jain, the learned counsel for the petition. Also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state. You are MS?
J. Singh for Lordship, appearing on behalf of M. Biswas.
So MS so appearing on behalf of Mr.
M. Biswas.
M. Biswas for the respondent number 2, and it is submitted by her that she has already filed their Okarat number on behalf of the respondent. We need here the scan copy have received? No. I see. Scan copy of the TCI has already been received. List the matter for admission hearing immediately after vacation as on a date to be fixed by the registry. Interim order granted earlier be continued till next.
Lordship, one extra copy, please.
Yes. Extra copy was not so provided to you. Further, the petitioner you were directed to serve an extra requisite extra copy to the respondent side during the course. If you can provide today itself, you can.
Bacho.
May I please your lordship? Your lordship, in this matter, scan copy of the TCR was called for your lordship, that is not received. So
My
remind
lord, I
the-
enter appearance for respondent number 2. Yesterday, I have filed wakalat.
Yesterday you have filed local.
Yes. So I need also some time.
Reminder may be issued your lordship.
You are Mr.
I.H. Laskar.
I.H. Laskar, the learned counsel for the petitioner also. But Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. And Mr.
Jiuddin.
Jiuddin appearing for the respond number 2, submitted that he needs some more time to file their affidavit, written objection, affidavit in opposition. Stop. Office note further reveals that the trial court case record is not yet received in spite of issuance of reminder. Registry will do the needful. Further issue reminder to the further issue reminder in issuing reminder calling for the trial court case record with a further direction to the learned trial court below to furnish the case record on or before the next date. Place the matter immediately after vacation as on a date to be fixed by the ministry. Was there any interim? No.
Your Lordship, there is no entry. The matter may be listed for admission column, Your Lordship.
Matter may be
Here has not
listed.
been received.
That again will make it. Then we are listing it on admission column. Admission.
Highly recommended.
এটা দেবার বাবা না? মাটি দেব একটু লাস্টে
May it please your lordship. Lordship, this matter will take some time and I'm led by Mr. A.M. Bora. So maybe it may kindly be fixed after the vacation or after Bihu vacations and
after Bihu vacation.
End of
after 5th of February will do. It's a hearing day. It's a hearing day.
Yes, yes.
The request made by the council. MS so and so. Distributor. We are also not in a position.
Yes, yes, your lordship, sir.
Interim order. Other side has taken adjournment. Continue interim order. Article 13. 1-3.
Actually, it's continued in the morning, early morning. It was
Morning, other side has taken adjournment.
two cases are there, you know. 12, 13.
12,
12 and 13. In 13, there were interim.
Interim order. And for the petitioner.
12 and 13, we grant time, the date was fixed on 21, 2026. So you were on interim on 12, item number
13.
13. Okay, we'll instruct our private secretary to add the line for continuation of the year. এইটো কোৱা আছিলে নে ৰিট সাবাৰিয়াই হেৰিটো বেলটো